very good morning to all of you, distinguished speakers and guests. It is a great pleasure for me to welcome you all to the fourth ICC India Arbitration Day today. We are hosting this flagship event after a gap of almost 2 years and blame it on the pandemic. And for the first time, we are doing it virtually. Thank you for joining us today. These discussions are very important to us as we firmly believe that sharing of knowledge at events such as these is essential not only for ICC arbitration in India, but also for India's evolution as a pro-arbitration jurisdiction. At the outset, a few words about ICC. ICC represents business organizations from more than 100 countries with a network of 45 million members. We are a non-governmental organization and enjoy special status with institutions like the United Nations and its specialized agencies. ICC's three main areas of work are rule setting, dispute resolution, and policy advocacy. This also includes essential business services such as arbitration managed by ICC's International Code of Arbitration, the world's leading arbitral institution. At ICC, everything we do is rooted in our core mission to promote cross-border trade and investment, helping businesses to meet the challenges and opportunities of globalization. Now, with the growth of international trade and investment, commercial transactions are increasingly becoming cross-border, raising concerns about resolution of disputes. The issues are not only limited to resolution process, but also concern enforceability. Today, multi-party contracts are common, thus making the jurisdiction issue very complex. Turning to local courts, especially in the wake of the pandemic, may not be a very business-friendly option anymore. We cannot enable business worldwide without effective alternate dispute resolution forums. Confidentiality, neutrality, impartiality, time and cost factors are some of the most lucrative offerings of arbitration. As we progress towards a more technologically advanced society, reliance on advanced telecommunication systems is increasingly becoming routine. I am happy to say that ICC arbitration rules have stood the test of time. More recently, in response to disruption caused by COVID-19, ICC issued guidelines for holding hearings virtually. Keeping a client mindset to the challenges, the 2021 ICC arbitration rules have paved the way for more efficient and transparent conduct of arbitrations, with increased tools, procedures, and technology at the tribunals and parties' disputes. You will hear more on this as during the course of today's discussion. Now, moving forward, in this inaugural session, we have several eminent leaders from the world of dispute resolution and business. Following this session, there will be two panel discussions and a keynote address in the end. Before I conclude, I wish to thank all our speakers today who have joined us and our partners, namely J. Sagar Associates, Khitan and Company, Shardul Amarchal Mangaldas and Company, Baker McKenzie, Cyril Amarchal Mangaldas, Clyde and Company Classes, and Mason. And last but not the least, all the delegates who have joined us on a Saturday to participate in today's proceedings. Without any further ado, I would now request Alexander Fassas, Secretary General, ICC International Court of Arbitration, to deliver his address. Thank you. Over to you, Alex.
Thank you. Thank you very much, Imran, and good morning from Dubai. Mr. Vijay Raja, Vice President of the ICC International Court of Arbitration, Mr. Sanjeev Kapoor, Vice President of the ICC International Court of Arbitration, Mr. Kunal Vahani and Ms. Pallavi Shroff, ICC court members for India, Mr. Imran Khan, Executive Director of ICC India, esteemed members of the ICC India Arbitration Group, dear colleagues and friends. It is an immense pleasure to be able to rejoin you all in the forum of the fourth ICC India Arbitration Conference, and extend the warm welcome and the best regards from the Secretariat and the court itself on this important milestone, as Imran has just explained. Much as the setting of our interaction today remains a virtual one, it is indeed coming with a lot of hope that this reconnection will ultimately lead to us meeting in person, hopefully in the not too distant future. In the few minutes that I have before me, I would like to relay some very broad points with regard to the way that the work at the ICC International Court of Arbitration and its Secretariat have been evolving since we last met. As you may remember, the Secretariat of the Court is one of two pillars providing dispute resolution services to businesses, states, and state-owned entities across the world under the umbrella that we loosely term dispute resolution services, the largest department within ICC, which on the one hand administers cases under the ICC arbitration rules, and on the other hand, administers cases under the various ICC ADR rules, mediation, expertise, dispute boards, and so on. Importantly, ICC Dispute Resolution Services is a department and a community that provides support to four distinguished bodies within the ICC network. The International Court of Arbitration that takes the decisions in the context of the ICC arbitration rules, the Standing Committee of the ADR Center, which has the equivalent role in all services other than arbitration, and importantly, the ICC Institute of World Business Law that provides leadership in the development of the theory and doctrine of international business law, and the Commission on Arbitration and ADR, which provides thought leadership on practical matters of arbitration and ADR. This is who we are, and this is what we have been doing for nearly a century. We have been known, and we continue to be known for service excellence. We have been consistently identified as the most preferred arbitral institution in the world, most recently in 2021. And we wear that badge with extreme pride and honor, and immense gratitude to all of our clients that have made that possible. But we want to go further than that, of course. And our strategic planning and thought have been developing at a rapid pace over the past few months. And I would like perhaps to share with you the main axis of the things that you can expect of us as we are drawing closer to the centenary anniversary of the ICC Court in 2023 and 2024. Our ambition, dear colleagues and friends, is to make ICC dispute resolution services the preferred one-stop shop for dispute resolution and dispute avoidance needs of businesses everywhere. As I mentioned earlier, on the one hand, we are already known for service excellence, and on the other, we have been developing certain dispute avoidance or non-contentious disputes processes for a long time. But drawing from the very useful opportunities that the pandemic and the global economic setting currently provide for us, we know that we need to be able to proceed further if we are to be successful in delivering along the lines of the broader ICC mission and our broader mission, which is to ensure access to justice for all businesses and, of course, strengthen the rule of law worldwide. This broad mission, ladies and gentlemen and dear friends, is broken down in three main objectives. And I'll be very brief, of course, because obviously this can take much longer. Our first main objective is to ensure that we will update not just our existing services, as we have already done, for instance, this year with the launch of the 2021 ICC arbitration rules, but also create new dispute avoidance services that will meet the needs of businesses, including small and medium enterprises worldwide. Our second objective is to strengthen arbitration infrastructure and mutualism worldwide. The ability to create capacity, the ability to spread the word with regard to how companies may proceed in making choices with regard to dispute resolution strategies, raise awareness on how an arbitral process can actually lead to a much more time and cost efficient resolution of a dispute, or how mediation or dispute boards or expert determination may equally assist parties under certain circumstances, is an important part of the second objective, making sure that we are seen as companions of corporates, as your companions in the way that you negotiate contracts, in the way that you perform your contracts, and ultimately in ways that you may want to avoid disputes or escalate disputes towards resolution is a core part of the second. And lastly, the third is to communicate the value proposition and the differentiated brand of ICC dispute resolution services around the world. And this is where I would like to actually take a short pause to emphasize the important work that ICC India, under the directorship of Imran Khan, and the Indian Arbitration Group have actually already delivered on. This is work that is still very much in progress, dear friends, and this is work on which we will be working hand in hand to make sure that we can communicate that proposition across India and sustain the Indian economy and the interests of Indian corporates as much as we can. I would like to end by briefly mentioning the arrival, which most of you probably already know, of course, at the position of our Regional Director for Business Development for Southeast Asia in Singapore, of Mr. Tejas Shawan, who is currently quarantining in a hotel in Singapore. But by the grace of his virtual background, all of that, of course, is now invisible. Tejas, a warm welcome back into the ICC family. I'm sure that all our colleagues in India and at the Indian National Committee are happy to see you back and look forward to working with you on the ground in realizing our missions and goals around the whole of the Southeast Asia region, and particularly, of course, India itself. Thank you all very much.
Thank you so much, Alex, for especially sharing these strategic priorities of the code as we proceed. And yes, of course, I'm sure having Tejas back will definitely add on to the work that we do. Now, before we move on to the next speaker, Mr. V.K. Raja, let me just briefly give, he needs no introduction, but I'll be just happy to share a few points about him. Mr. V.K. Raja is an international arbitrator. He is the former Attorney General and Judge of Appeal of Singapore, and he's also the Vice President of the ICC International Court of Arbitration. Mr. Raja was appointed a senior counsel in 1997, and while on the Singapore bench between 2004 and 2014, he authored more than 200 reported judgments, including several landmark appellate decisions on arbitration-related issues. After his retirement as the Attorney General in 2017, he has returned to private practice. I will request Mr. Raja to kindly deliver his special address. Mr. Raja, the floor is yours. Thank you.
Thank you very much, Mr. Kapoor, Mr. Fessus, Mr. Khan, Mr. Chauhan, friends. Good morning. I'm going to touch on a few topics, but let me first address a very topical issue, India's ambition to be a global arbitration hub. The Economic Times reported on 16 July 2021 that the Honorable Law Minister, Mr. Kiren Rijiju, affirmed India's ambition to be an international arbitration hub. He said that to achieve the Prime Minister's vision, the Arbitration Council of India and the New Delhi International Arbitration Center ought to be set up. Establishing these institutions would not only help in reduction of litigation for the appointment of their arbitrators, but would promote institutional arbitration, which, in his words, is the need of the hour. Besides, the efforts in this direction would enhance enforcement of contracts and help improve India's position in the World Bank ranking on EODB. Additionally, these initiatives would further encourage foreign investments and strengthen the Indian economy, he added. Now, while there are no quick fixes to realize this holy grail, as a keen student of developments in the Indian arbitration landscape, I must say that I've been left breathless by the enormous transformation over the last 2 decades. This is no better illustrated than by the remarkable sea change in the stance adopted by the judiciary, particularly the Supreme Court, towards international arbitration. It bears mention that as recently as 2002, the Indian Supreme Court in Bhatia International inexplicably held that Indian courts could exercise supervisory jurisdiction over foreign arbitrations, regardless of seating, unless this power had been expressly or impliedly excluded. And you need no reminding as to the unhappy saga of the White Industries case. Happily, within a decade, in Anacon India versus Anacon GmbH, the Supreme Court recognized the principle of minimal judicial intervention and held that the role of courts is to support arbitration and not to undermine it. In Shin Itsu Chemical versus Aksh Optifiber, the court clarified that it is a prima facie inquiry that must be carried out by the courts when deciding on the enforceability of an arbitration agreement. The court was not required to make a final and conclusive decision on this issue. This approach was affirmed by the 2015 amendment to the Arbitration Act. In 2011, in Government of India versus Vedanta, the Supreme Court clarified that merits of the award are not open to review by the enforcement court, and errors of judgment are not a sufficient ground for refusing enforcement of a foreign award. Notably, the court considered case law from foreign courts, writings of academics, and practice guides, thereby unambiguously signaling its intention to adopt international best practices. In PAASL Wind Solutions versus GE Power Conversions, the Supreme Court helpfully clarified that two Indian parties may choose a foreign arbitral seat. More recently, Indian arbitration jurisprudence has assumed global thought leadership on important areas that have attracted widespread interest and praise from the global arbitration community. The Supreme Court adopted the group of companies doctrine and actually took it further than the French courts in the Clara Controls case, where it held that a non-signatory forming part of the same corporate group as a signatory could be made a party to the arbitration, where it is clear from circumstances surrounding the transaction that the mutually held intent was to bind the signatory as well as the non-signatory to the arbitration agreement. Most recently, just a few months ago, in the Amazon.com versus Future Retail Limited case, the Supreme Court clarified that the Arbitration and Conciliation Act permits the recognition of emergency arbitration. All these decisions have been warmly applauded by both the Indian and global arbitral communities, as well as chambers of commerce, both domestic and international. However, building a global hub or a preferred seat for international arbitration requires much more than an accomplished judiciary. It requires strategic long-term planning by policymakers to visualize, build, and sustain an arbitral ecosystem. Both the hardware and software matter. The standing that the current leading Asian arbitral centers, Singapore and Hong Kong, enjoy has not come about by accident. It has taken decades of planning and the sustained, consistent, and careful execution of policies to nurture their arbitration ecosystems. Along the way, policies and practices have been constantly recalibrated. Inter alia, tax laws like withholding taxes for arbitrators have been removed, and incentives have been given to legal practices for attracting foreign work into the jurisdiction. Laudably, the Indian government has recognized the need for a centralized approach. The 2017 report of the High-Level Committee to Review the Institutionalization of Arbitration Mechanism in India, chaired by Justice Sri Krishna, points in the right direction. But more can and should be done if India seeks to be recognized as a preferred global seat for international arbitration and a thought leader. India can and should aspire within the next 2 decades to be admired, not just for its laws and processes, but also for its people. Its thought leaders should aspire to achieve global recognition as being among the leading global arbitrators, counsel, and academics. Some Indian universities should aspire to be recognized as having the best international arbitration programs to be found anywhere. To do this, even more thought must go into the ways and means that are necessary to nurture a first-class arbitral ecosystem. What might be the cornerstones of a vibrant arbitration ecosystem? Some are obvious, others, though necessary, are not immediately apparent. Let me share my observations in no particular order of importance. First, the architecture of supportive natural laws that must be constantly kept up to date to keep pace with the ever-evolving arbitration landscape. This is a very dynamic process. It is encouraging that the government has shown its support by introducing amendments to the Arbitration and Conciliation Act in 2015, 2019, and now most recently in 2021, though my friends in India tell me that the jury is still out on the benefits of the latest amendments. Second, a judiciary that understands and supports international arbitration. This seems to be already in place at the highest level for the most part, though perhaps judicial education at state levels can improve. Perhaps the Judicial College might wish to consider working with the ICC on how to build on existing programs. Further thought might be given to the feasibility of establishing specialist arbitration first instance courts in 2 or 3 cities with the most arbitration activity to promote consistency and efficiency in decision making. Third, growing an arbitral community of competent and knowledgeable arbitrators and counsel. Both knowledge and experience are important. In the last decade and a half, standards of Indian counsel have been raised exponentially through international exposure and secondments. I've seen this with my own eyes. The best can now hold their ground against the international best. But that's not enough. It is imperative that this small pool be expanded, especially considering the immense volume of cases involving Indian parties. Arbitrators get experience by sitting with other leading arbitrators, and this community in India too has seen significant positive changes. Gone, or perhaps I should say almost gone, are the days when arbitration sitting meant a 2-hour hearing followed by long teas and even longer adjournments. Perhaps while global debate continues about common ethical standards for counsel, the Indian bar can show some thought leadership by setting out its markers. Fourth, knowledgeable users. This includes the business community as well as corporate counsel. They should know when and how to use the arbitration process and how to cut their cloth and hold their counsel accountable. The various chambers of commerce, both international and domestic, can play an important role here in edifying them. Fifth, education and training. Here, for education, this ought to include Indian-based publications, including treatises and periodicals that illuminate what is happening globally to the Indian community and vice versa. This is vital. Apart from keeping the community current with Indian developments, these publications should also serve as a platform to showcase innovations and advances taking place in India, as well as the enormous pool of available talent. There is currently a lack of sufficient number of these publications. I note 3 arbitration-specific journals which are making good progress: the Indian Journal of Arbitration Law, the Indian Arbitration Law Review, and the Journal of Arbitration, the last by the Delhi International Arbitration Center. There's room for more and, of course, greater diversity. The ambition must be to anchor in India a leading global arbitration periodical or 2. Then there is the all-important task of continuing education for those now practicing and those who aspire to join the community. Law schools must work with the judiciary and the bar to do this. You need more specialist arbitration academics who write prolifically. In Europe and the US, many senior arbitration academics also practice as arbitrators. This cross-fertilization is enormously beneficial. LLM courses comparable to the best anywhere should also be designed. Sixth, encourage and incentivize global arbitration institutions and specialist international arbitration practices to operate from India, with a stipulation that the majority of their staffing positions will be filled by Indians. This will accelerate knowledge transfer to able younger Indian arbitration professionals. I now turn to two big problems currently bedeviling international arbitration: costs coupled with delays and complexity. This is a difficult topic that's beyond my remit for today, but I do think that institutional arbitration helps to ameliorate these problems in many ways that ad hoc arbitrations are ill-equipped to cope. Allow me to amplify this. Arbitration institutions provide structure to the arbitration and reduce delays and other certainties. First, predictability. Since arbitration institutions such as the ICC have pre-established arbitration rules, the parties will know the procedural rules and likely costs as well in advance of any actual dispute. Two, efficiency and reliability. The arbitration rules of most leading institutions have been fine-tuned over several decades. And in fact, the ICC are the thought leaders in this over the last 100 years. And they use the experience gained from administering thousands of arbitrations. Contrast this with ad hoc arbitrations, which can be inefficient if parties have not adopted any rules in their arbitration agreements. Further, if the arbitrators are compensated on an hourly basis without oversight, there's little incentive to expedite the arbitration. Third, arbitrator issues. Arbitral institutions also play a vital role when it comes to the appointment and challenge of arbitrators. I'll let the panelists in the afternoon amplify this. Finally, I'd like to conclude by emphasizing our overarching collective responsibility towards younger professionals and those who aspire to have a career in international arbitration. I've come across many highly impressive young Indian lawyers. The bar and the universities have an ongoing responsibility to provide relevant academic and practical instruction of international best practices. But you too must have the drive to learn and excel. Equip yourself with perspectives from other jurisdictions and keep in touch with the most recent developments. Join international bodies. The young ICC will welcome more participation from India. Be curious and constantly question principles, practices, and decisions that may have become anachronistic. The developments in the last 2 decades have shown that international arbitration is anything but static, and arbitration stakeholders in India must be ready to keep abreast with international best practices and standards to make India the vibrant arbitration hub it aspires to be. Well, thank you very much for having me and bearing with me. And I wish you a productive afternoon ahead.
Thank you very much, Mr. Raja, and thank you for articulating your thoughts so very well. I was completely, glued on and listening to what all we can do collectively to promote international institutional arbitration in India. Thank you very much for joining us, and thank you for sharing your thoughts. Now, before we move on to our next speaker, Claudia has shared. Claudia Solomon is the president of the ICC International Court of Arbitration. And she has shared her video address. I would like to just briefly mention that she is the first woman to lead the ICC court in its almost 100-year history. Claudia is also an independent arbitrator specializing in international investor, state, and complex commercial disputes. We'll just play her video.
I am so pleased to have the opportunity to welcome you to ICC India Arbitration Day, and I look forward to joining you as soon as possible in person. As you may know, I worked as outside counsel for more than 25 years, representing clients from all over the world, including from India. I loved diving into a case and getting to know my client's business, or in the case of my work representing governments, understanding their history. I loved getting to understand my client's strategic objectives and developing a strategy to meet those objectives. So why did I leave New York, the city that never sleeps? I wanted this role because I really believe in ICC, and I really believe in its purpose. ICC is the global voice of business, founded in the wake of World War I over 100 years ago by a pioneering group of entrepreneurs, seeking to promote peace and prosperity through cross-border trade. They understood that to facilitate cross-border business, there needed to be a dispute resolution procedure that met the needs of global business. And they understood the importance of access to justice and the rule of law. That purpose is no more true than today. As cross-border business has continued to increase, businesses around the world know that ICC is a trusted institution to resolve those disputes. Today, ICC administers cases involving parties from 145 different countries, with arbitration seated in 113 cities in 65 different countries, and awards drafted in 13 languages. Businesses trust ICC because they know that ICC is the only arbitral institution that is truly international, not tied to any one geography or subject to shifting political winds. Businesses trust ICC because they know that ICC understands the needs of global business. Our case management services are second to none. The counsel teams are accessible, responsive, and incredibly knowledgeable, and I am thrilled to be working with them. We have case management teams in 6 offices, including Paris, Hong Kong, Singapore, Sao Paulo, New York, and now Abu Dhabi. You can reach out to them whenever you have a question or concern in your language and in your time zone. And the work done by the ICC court ensures that the process works. This is the most diverse ICC court in its history, with 195 court members from 120 different countries, with more women than men. I am thrilled that Sanjeev Kapoor from India is serving as one of our vice presidents, along with VK Raja, based in Singapore. They are 2 of my most trusted advisors. We also have 2 court members from India, Kunal Vijani and Pallavi Shroff, and I want to thank them for the incredible amount of work they do. The ICC court performs 2 essential functions, unique to ICC arbitration. First, the ICC court reviews draft awards before they are finalized to ensure that the tribunal has considered the issues to be decided, has taken into account all of the arguments of the parties, and that its reasoning is clear. Parties know that they are getting what they bargained for, the best likelihood of an enforceable award. And second, the ICC court determines whether to accept or reject challenges to arbitrators, assessing their independence and impartiality. And the court's reasons are now provided to the parties if requested. This ensures transparency for the process among the many important initiatives launched by my predecessor, Alexi Moore. Now, while reasons are only provided to the parties, we will soon be in a position to publish a compendium of anonymized decisions, which will enable parties to better understand ICC's approach on such matters. And with this type of resource, I expect there will be fewer challenges, as parties have insight as to whether the person they seek to appoint is likely to be successfully challenged, and they can adjust their selection accordingly. Transparency equalizes access to important information. Instead of some participants having exclusive knowledge based on their previous experience, all parties, wherever they are in the world, can get the information they need to make better decisions. So let me just close with the discussion of values. In one of my last hearings as counsel, before the pandemic, I was working closely with an associate who has type 1 diabetes. We worked very long days in the war room together as we prepared for the hearing. And as I helped get the associate ready to take his first cross-examination of a witness, I hadn't worked with someone who has type 1 diabetes before. And it was eye-opening to see what he has to do to monitor his blood sugar level, adjust his food intake, and inject insulin, all in the midst of intense hearing preparations. And then we were in the hearing, and it was time for this associate to do his cross-examination. And all went extremely well, and I was so proud of him. And then opposing counsel did a short redirect and didn't really score any points, so all was good. But then the tribunal began their questioning, and they started to get quite intrigued with some of the issues. And I saw that my associate, sitting in the first chair at the hearing for the first time, was getting a little agitated. And he looked around, and I asked if he was okay, and he said yes. And then the tribunal just kept asking more questions. And suddenly, the associate ran out of the hearing room, and the tribunal looked askance, and I assured them they could continue. But to this day, I regret what happened. If I had only said to the tribunal at the start of the hearing that we may need to ask for a break at what may seem like an inopportune time, but I can assure you it's because of the health of my team and not for strategic reasons, we all know the tribunal would have, of course, agreed. I would have shifted the burden from the associate who was too worried about losing his opportunity to advance his career and get the experience of cross-examining a witness to raise the issue. I could have pierced the silence that has lasted for too long. Now, as an arbitrator, I include as part of the agenda at the preliminary hearing a question whether there are any disability inclusion issues that need to be considered. It is a question that needs to be asked at the start of the hearing as well. And this is the reason the ICC announced during my first week in office the creation of the Task Force on Disability Inclusion and International Arbitration. Businesses from around the world, from multinationals to SMEs, small and medium-sized enterprises, recognize the value of diversity, and they recognize the value of inclusion. Businesses are increasingly choosing to do business with those who share their core values. As the new president of the ICC Court, I am focused on assuring that our dispute resolution services meet the needs of today's global business, and we have a strong partnership built on shared values. I thank you very much and look forward to working with you.
I must add to that in my limited interaction with Claudia. She is very, very keen on building the profile of the ICC Court in India, which is very welcome news. Herself, Alex, and Tejas, we've had this discussion a couple of times, and we are really looking to develop the ICC Court further in India and in the region. And she's very keen to visit India soon too. So unfortunately, we do not have Mr. Deepak Bagla with us today. He had some personal reason and he really couldn't join us, so which is okay. I would now request Mr. Tejas Chauhan. He is Director South Asia, ICC International Court of Arbitration. Tejas is not new to us. He is an old hand and has been with ICC, and he knows the area and a lot of people who are present here today also. Tejas, please go ahead.
Thank you, Imran. Good morning, ladies and gentlemen. As Alex mentioned in his remarks, I joined from Singapore, where I'm currently in quarantine in a hotel. So in case the lighting is not good, or if you hear the room bell to signal that my lunch has been kept outside, you know what is happening. Mr. V.K. Raja, Vice President, ICC Court, Mr. Fali Nariman, who I also see has joined in today, and we're delighted to have Mr. Sanjeev Kapoor, Vice President, ICC Court, Mr. Kunal Vijani, and Ms. Pallavi Shroff, ICC Court members, Mr. Alexander Fesses, Secretary General, ICC Court, my colleague at the Secretariat, Mr. Akhil Unnam, Deputy Counsel, Mr. Imran Khan, Executive Director, members of the ICC India Arbitration Group, speakers, my old companions and colleagues from ICC India, Mr. Utpal Kant and Mr. Sudhir Lamba, distinguished guests, ladies and gentlemen. On behalf of the ICC Court, I would like to thank you for taking out the time to join us on this Saturday morning. A very warm welcome to all of you. Our sincere gratitude to ICC India for organizing the 4th ICC India Arbitration Day, and to the sponsors who have come on board to support this virtual event and ICC India in turn. We are hopeful that the ICC India Arbitration Day, the next edition, will be in person. ICC conferences have always garnered extreme interest. Our physical events have more often than not been booked to capacity, and the virtual event as well, this one, we had to close the registrations yesterday, knowing well that the Zoom platform can only allow limited participants. For us at the ICC, these are not just numbers that help us promote the next event. The attendance is a testimony to the high standards and trust that the arbitration community places in us. It is a belief that they will take back insights and tips from the discussion today that will be crucial and relevant for the arbitration practice. Speaking of trust, the ICC continues to be the most preferred arbitral institution with the highest caseload of 929 filings once again. Our cases come not just from Indian parties, which continue to be among the top 10 nationalities, but from across the globe. They come from the USA, they come from China, they come from UAE, and they also come from France. They're seated not just in Singapore or Paris, but in 65 other countries. It is therefore that the ICC does not have any interest in promoting one jurisdiction, and nor is it tied to any geography. Our interest is equal in all arbitrations that are submitted to the ICC court. And for us, it is a question of service. And that service is guaranteed by our case management teams, 2 of which are in Asia alone, and our court members such as Mr. V.K. Raja, Ms. Pallavi Shroff, Mr. Sanjeev Kapoor, and Mr. Kunal Vajani, who spend their time and resources to go through the draft awards submitted by tribunals acting in ICC arbitrations, all to ensure that the parties have an enforceable, a well-structured, reasoned award. This is the hallmark of an ICC arbitration, and this can be done only by way of having the reach and resources that the ICC does. It is by way of our 12 case management teams, which are spread across 5 case management offices. It is by several counsels like Akhil, who speak multiple languages, and by the 195 court members worldwide. We heard from the ICC president, our Secretary General, Alex, a short while ago, who very much look forward to being in India. It is evident that the Indian jurisdiction is an important jurisdiction for the ICC. It is a jurisdiction that we think we can contribute in and work together to make dispute resolution work. Mr. Raja mentioned a lot of these steps that India as a jurisdiction should take to make it a global hub of arbitration. The ICC very much looks forward to supporting that. We are in fact working on a lot of those initiatives with Mr. Raja, of course. We can also do this with the support of our representatives on the ground and in India, who we really count on. Our National Committee, ICC India, our court members, the ICC India Arbitration Group, our 4 YAF representatives, which is the highest for any country. And most importantly, with the support of the Indian arbitration community, which comprises all of you. Now, there are several questions regarding the ICC that you may have, and we've had a lot of those. There may be misconceptions, there may be questions on costs, there may be questions on timelines, autonomy of parties, services that the ICC will provide for the fees that you pay, the appointment of arbitrators. Should you have any of these or any other, please do not hesitate to reach out to me. You can call, WhatsApp, email, or send a LinkedIn message. I'm sure that Alex would also be available to answer any of these. But please do not let that dispute resolution clause be a standard copy-paste clause, for nobody is thinking of a divorce when getting married. Coming back to events and networking. With this one marking the year end, we remain committed to organizing events and sessions which provide for meaningful exchanges and discussions once again next year. While we will continue to organize these large events, the focus will also be on curated discussions, roundtable sessions, and closed-door interactions. In that stead, I also wanted to highlight the importance we place on meetings with law firms and in-house counsels. We had an in-house counsel roundtable session organized by the ICC Singapore group a month back, where we discussed the expectations of in-house counsel from the dispute resolution process and how they can benefit from ICC services. We've had a similar one for India. We feel that these sessions allow companies in the ICC to benefit from each other's perspective, experience, and feedback. Claudia, Alex, and I would very much welcome such sessions for your clients or colleagues. If there is a session that you would like to organize for your clients, we would be delighted to participate, speak, and support you. For the young practitioners out here today, who I gather are a lot, And as Mr. V.K. Raja mentioned, may I also invite you to please become members of the ICC Young Arbitrators Forum, or as we call it, the ICC YAF. It will provide you with networking opportunities and fun sessions for those aged 40 and under. It would also provide you the opportunity to become ICC YAF representatives from India and host sessions yourself. I will paste a link to sign up in the chat box after my remark, and I urge you to join if interested. Lastly, I take on this new role from someone who most of you know very well, Abhinav, and I'm personally a big admirer of the work that he has done. I hope to be able to continue on the same path and progress further. I count on your support to do this and remain available for any suggestions or feedback that you may have. Wishing everyone a great conference and insightful discussions ahead. Thank you.
Thanks so much, Tejas, for sharing your views. We are just in time for our first panel discussion. It's titled Institution, Tech and Experts, Essential Stakeholders of an Effective Arbitration Ecosystem. The session will be moderated by Mr. Ashish Chok. Ashish is a partner at Baker McKenzie, Singapore. Ashish, over to you. Thank you.
Good afternoon, everyone. Thank you very much, Imran, Tejas. Our first panel discussion, the topic is institutions, tech, and experts, essential stakeholders of an effective arbitration ecosystem. I have the distinct pleasure to moderate this panel, which comprises of the following individuals. We've got Ms. Karen Goff. She is an arbitrator and barrister, 39 Essex Chambers, and she's based in Jamaica. I have Mr. Prakash Pillai, who's a partner of Clyde & Co. Classes in Singapore. I have Ms. Gauri Rasgotra, who's a partner at Cyril Amartan Mangaldas in Delhi. And I have Mr. Rohit Singhal, who is the CEO of Massin. Welcome all of you to the panel. It's a very diverse panel. We have obviously a barrister, an independent arbitrator. We've got counsel from an international law firm, counsel from a local law firm in India, and we have an expert, particularly with respect to construction claims. So I'm actually very intrigued to hear their responses and seeing what a diverse background would mean to the responses they provide. I wanted to just kick off with the first question, and it relates to the new ICC rules that were recently implemented in 2021. And it in particular relates to Article 12. Article 12 of the ICC rules 2021 provides and stipulates for the constitution of the tribunal. And there is a specific provision, Article 12.9 of the ICC rules, which is quite novel, and some would even say it's a bit controversial. I want to just read for the benefit of everyone the specific provision before we get into what it could possibly mean. Article 12.9 states, notwithstanding any agreement by the parties on the method of constitution of the arbitral tribunal, in exceptional circumstances, the court may appoint each member of the arbitral tribunal to avoid a significant risk of unequal treatment and unfairness that may affect the validity of the award. And so the question, therefore, with respect to Article 12.9 is this a departure from the principle of party autonomy, in that the ICC court now has a residual discretion in exceptional circumstances to deviate from any agreement by the parties on the method of constitution of the tribunal? And if that is so, should arbitral institutions like the ICC have such a residual power, and how should it be applied? And then I think the broader issue is, would it be more effective in an international arbitration if it was just left to the parties to appoint their own arbitrators? So to kick off, I'd be grateful for the views of Karen, and perhaps Prakash could chime in after that. Karen, I think you're muted, so you might want to just unmute yourself.
That's true. That's a terrible way to start. Well, good morning, everybody. I'm actually not based in Jamaica. I just happen to be here this week. It's lovely to be with you. Thanks so much for the invitation. Is it a violation of the principle of party autonomy? I would say not, because if you choose the ICC rules, you've exercised your right to party autonomy, and those rules contain Article 12.9. Is it a good idea, Article 12.9? I think yes, it is, because we all know that when parties enter into an arbitration agreement, that the field is not necessarily level. People have different bargaining powers. And there are occasions, and as the ICC says, in exceptional circumstances, when there is a need to level the playing field. And the concept of leveling the playing field is not foreign to arbitrations and to arbitrators. So there is a case for institutions and the ICC here to have this power. I think it's a good idea. They already have default powers, and this is really no more than an extension of this. The primary concern, if you have arbitration, is to get a valid and enforceable award. And so they've already stated that this is the reason that they're going to enter the arena and perhaps take over and appoint the tribunal. So I don't see anything wrong with that at all. Generally, parties are free to choose their own arbitrators. Generally, they will do so. But again, we all know that they don't always do that. So yes, if parties don't want Article 12.9, they can either amend the rules or they can choose different rules. Again, they have the right to exercise party autonomy. Powers only exercisable in exceptional circumstances, and we can all envisage circumstances when they would need to exercise those powers. For example, if the local law prohibited one party having too much power, or there was some problem if the arbitration agreement skews the balance of power in the appointing of the tribunal. So good idea, I think. I don't see a problem with it at all.
Yeah, well, it's good morning or good afternoon if you are in Singapore like I am. Good morning, I suppose, just about if you're in India or Jamaica, I guess. It's a pleasure to be here. It's been a long time, I think, because of COVID that I've been to India. Used to do the conference circuit in India quite often, but now, been homebound for quite a long time. So it's a real pleasure. And thank you, Ashish, for the question. So this is a sort of a very interesting one. In some ways, I think the ICC is showing a little bit of its French roots, which values, equality in sort of on par with that of party autonomy. So if you remember the great French motto of liberté, égalité, and fraternité, freedom and equality are on par with each other. And I think this is an attempt by the ICC to sort of bring into play that concept of equality. I think it also reflects a little bit, and I'll just look at it from a broader, more conceptual level. Look at it from, from the point of view of what the arbitration regime is trying to achieve. There is, I would say, a modicum of self-doubt within the arbitration regime, because it's trying to make up its mind whether, it should give parties some freedom, because that's what it's there for. And with all of that comes, some of the excesses and perhaps injustices of things, or whether you try to do something that, makes it a more just type of result. So it is that sort of tension that's always in play. I mean, the rules against natural justice is a sort of attempt to try to sort of find some kind of middle ground where you give the parties, a lot of freedom to do as they wish, but subject to certain limitations. And this is a sort of something similar to that. So as I think Karen mentions, it's meant to come into play only in exceptional circumstances. I think that's very important. Also, if you look at the wording, it seems to be focused on the issue of enforcement, where there's a significant risk of unequal treatment and unfairness that may affect the validity of the award. So they're looking at it from an enforcement more point of view than anything else. So, that's where, as Karen mentions, I think the law of the seat, that may not allow the tribunal to be constituted unilaterally, if that happens, it would affect the validity. But, but I think there's a broader point to that, because validity also, enforceability also depends on, on whether or not an award can be set aside. And that is also in the Lyon Convention and so on. So, and one of the issues, again, talking about natural justice, if you have an unequal situation, in other words, you have an arbitration agreement which gives one party the right to appoint its own general manager, I mean, how just is this proceeding going to be? He's not likely to be following the rules of natural justice too closely and so on. So all of that sort of thing comes into play. So it's going to be very interesting to see how they sort of manage this, and to what extent the ICC is going to sort of intervene and start to constitute tribunals. I think they will keep to the rule of being very sparing and stick to the exceptional circumstances point. But and also there's a fine line here, because one of the grounds for resisting enforcement is that the parties are not, or the tribunal was not constituted in accordance with an agreed procedure by the parties. So if the ICC comes in, there is some tension with that. But obviously, I think we can reconcile that by saying that when the parties have chosen the ICC, they have implicitly accepted that, and therefore what the ICC decides to be the right tribunal is what the parties have decided. But one can see, that if you don't do this properly and carefully, you can run foul of a few enforceability type of issues. So good idea, but care should be taken. I think that would be my view.
Thank you, Karen and Prakash. We will change tracks and we'll talk about experts in a minute, but I just wanted to add, before we do that, the Q&A window is enabled. So if there are any questions from the audience, we'd be happy to take them. I note there is one question on Article 12.9. I'm just trying to read it right now. It says that the article would provide the following reasons. Okay, so I think that this is something, header, that Prakash did talk about, that very focused on the enforcement. And I think that's one of the key considerations of Article 12.9. It is obviously a departure from what ordinarily we would, view as an institution's role. But there are, as we've discussed, there are cogent reasons for that. Let's proceed now to another very topical issue relating to experts. And experts obviously are also an essential stakeholder in the effective arbitration ecosystem. Rohit, you've obviously got a very diverse and significant experience as an expert. And one of the issues I think most of us have encountered in some shape or form is that in an international arbitration, there's always this question, would it potentially be more effective for a tribunal to appoint an expert rather than the parties appointing experts? I mean, there is always this view that party appointed experts are nothing but hired guns. Is that a correct perception? Is that something that ought to be displaced? Are there any drawbacks that you would consider if an expert was appointed by tribunals rather than the parties? And what other alternatives could you perhaps think about if a tribunal was not to appoint an expert as opposed to the party? So perhaps, Rohit, if you could kick off, and then I'm also going to ask Gauri for her views.
Thank you, Ashish, for this question, and good morning, good afternoon, everyone. It's a privilege to be part of ICC India Arbitration Day. I'm really looking forward for in-person events. ICC events have always been hit, and they are my personal favorites. Now, talking about the question which Ashish you have put to me is the issue of party-appointed experts versus the tribunal-appointed experts. And that has been a issue which has cropped up many a times in our export engagements, and a lot of times when clients who are new to the concept of exports are disturbed and perturbed when we say we are an independent export, and we are not, even though the fee is going to be paid by the parties who are appointing experts, but our opinions are going to be independent. So then the question comes is that in that case, why is tribunal not appointed the expert? I've had the opportunity of acting both as party appointed expert and tribunal appointed experts. As a matter of fact, in Middle East, most of the courts are going in for court appointed experts, unlike in international arbitrations where party appointed experts are generally the preferred version. Well, both these concepts have got their plus and minuses. If you have a tribunal appointed expert, then many a times the parties are not able to get to the bottom of their cases. The parties, both respondent and claimants, are generally emotionally connected to their case, and they think that whatever is their pleadings, whatever their case is, the right case which they are putting forward. Now, once you have a party appointed expert, then the experts are going to give an independent opinion and view of what exactly is their case, what are the drawbacks, what are the positives and negatives of the case. And at many a times, you would see that parties in that situation might even come forward for an amicable settlement, or may modify their pleadings accordingly. And in case as you rightly said, a lot of times there is this allegation of hired guns, that the experts are not giving independent opinions, and especially if you are a party appointed expert, there is a lot of pressure from the party that how can you give an opinion which is absolutely distinct and different from the pleaded case. But as an independent expert, our duty is towards the tribunal. Our primary obligation is to provide an independent opinion. So we will have to give an independent opinion to the tribunal, whether it is in favor of the case of the party who is appointing us, or against the case for the party who is appointing us. My personal favorite is, of course, party appointed expert. But if I talk about India now, India is quite different. I have come across almost in majority of the circumstances where in construction disputes, especially, there are hardly any experts being engaged. And nowadays, the concept of expert is gaining traction within India, but there also it's only probably the party who is acting as a claimant is appointing the expert rather than respondent. And sometimes, respondent, when they see a claimant's expert, then they will go for the expert to be engaged. So from an Indian perspective, nowadays I have seen that tribunals have started appointing independent experts because the parties are not appointing experts. And when the issues are complex and complicated, like engineering issues, construction issues and all, so tribunals are appointing expert. So just to conclude on this issue, that both are formats of appointing expert. My personal favorite is party appointed expert, as I said, because then parties are able to get to the bottom of their case. But Indian disputes have seen very little attraction towards party appointed experts, and tribunals nowadays are appointing expert. Now, how to assure that the expert opinions are coming out to be more fair and are equitable for the parties is kind of joint expert conferencing, joint reports and all. In construction disputes nowadays, what I have seen internationally is that the tribunals in the very first instance are asking both the experts, both the party appointed experts, to come together, agree on the methods of delay analysis, quantification of the claims, then prepare their report, then prepare reply report, update their joint statement, and then during the cross-examination have witness conferencing to ensure that both the witnesses are in sync with each other. And many a times in construction disputes nowadays, when you have quantification disputes, majority of the time the quantum experts are coming on the same platform. So these things are there, like witness conferencing, which can make sure that you have the diverse views of the experts are brought on the same platform. Thank you.
Good morning, everyone. It's a pleasure to be here with all of you. And just to add to what Rohit has already explained in detail about expert teaming, but let me start by saying that an expert opinion should be impartial, unbiased, and uninfluenced. On one hand, there are concerns regarding the independence of party-appointed experts, and on the other hand, there is distrust when a tribunal appoints an expert. In the traditional process, there is a lot of time that is spent on the credibility of the witness, of the expert witness. There are efforts that are being made to simplify this. Now, what is it that we can talk about is one such process is expert teaming, which is also known as concurrent evidence or hot tubbing. Let me just explain very quickly what this is. There are many variations to the expert teaming approach. Once the experts prepare a report, there is a joint statement of the experts and what they agree upon, what they disagree upon. And then there is a concurrent evidence on the joint statement where the arbitrators, the lawyers, as well as the experts are questioned. So all of them can question the experts. What is the important thing about expert teaming and why it's gaining some momentum is that it saves considerable time and cost. The second issue is that it crystallizes areas of disagreement and agreement. The third is that it focuses on real issues. The more thing is that it promotes the independence of the experts. But here, there is a lot of trust on the arbitrators to maneuver and to ask the real questions so that the real fair opinions come out of the expert witnesses. There's another important thing, because I come from India, is to tell you that the Delhi High Court has, on the original side, has got hot tubbing rules. And these are being used in the court system. And there is a case of 2019 of Micromax versus LM Ericsson, where the judges explained how this hot tubbing genuinely works. There are many countries which follow in their national laws the hot tubbing or expert teaming concept. And I think institutes should also now start adding them in their rules. Many have done so, many need to do so, because it will simplify the process. That's all I wanted to talk about on expert teaming, Ashish.
Okay, thank you very much, Rohit and Gauri, for your views. Just an allied question on experts. So, Rohit, you mentioned about complex arbitrations and obviously the role of experts. And one question that I think is very relevant these days is that in complex commercial arbitrations, is a virtual hearing, and we've done so many of these in the last 2 years, are virtual hearings an effective way for an expert to give evidence? Maybe I could start with Rohit and then Prakash. Maybe you could just chime in after that.
Thank you, Ashish. 2020 and 21, because of COVID, almost all hearings were virtual in nature. Now, at the beginning of 2020, when I had my first virtual hearing, I was quite skeptical that whether I'll be, how it is going to go, whether technology is going to be favorable, supportive of the hearings and all. But after that first hearing, I've kind of become a fan of virtual hearing. For two reasons. Number one, it's quite cost effective. You don't have to travel, and especially with travel restrictions and all, you're able to handle, everything very smoothly. And secondly, I have had instances where, multiple disputes and arbitrations hearings are in one single month. So you have an overlap and you are able to switch from one to another because of the bare fact that it's a virtual hearing. In terms of, complex arbitrations, yes, virtual hearings have their disadvantages. Like, for example, you don't get to see the body language. You don't, when the lawyers are cross-examining the expert, and you don't get to see that, the body language and the eye contact is sometimes missing. But otherwise, besides that, I don't see that virtual hearings have any problems. Even if it is a complex arbitration, I've been involved in some of the most complex investment treaty arbitrations and all virtually, and wherein the hearings have went on, cross-examination of experts have gone in for 2-3 sessions continuously for 2-3 days, and things have been quite smooth. So I don't see that virtual hearing is having any problem on expert testimony. Maybe Prakash could throw light on the other aspects of hearings like the fact witnesses and the the arguments and all, which I leave it to Prakash to answer. Thank you.
Yeah, thank you, Ashish and Rohit. So the question, whether it's effective, I think, it was put to the test during this COVID period, I think as Rohit has pointed out. And, it has, I would say, passed that test. So I think there's broad consensus now that virtual hearings are effective. I mean, in the sense that you get the job done, you carry out an arbitration proceedings with a certain level and standard of communication, which is carried by today's technology, and it works. So and people have been writing about it and praising it, and many articles on this right now. But I think one of the points that we need to consider is that while it may be effective, is it optimal? So that's a slightly more complicated question, because just because it's effective, does that necessarily mean that it's the best thing to do? Well, it's similar, I suppose, in some ways. I mean, arbitration is a human process. There are all kinds of things that come into play with that. Cultural factors, psychological factors that ensure sort of chemistry between people, the ability to build a rapport with the tribunal. And and in the case of experts or any witnesses for that matter, as Rohit points out, the body language and all of that. So it's a little bit like the webinar we're having today. I mean, it's effective, isn't it? But is it optimal? I mean, I would much rather be in a room with all the speakers. My old friend Gauri is there. I can see. It'd be nice to catch up. Ashish, not seen you for a long time as well. Karen, I've not met you. It'd be nice to meet you in person and see the audience, get a feel for what they're interested in, and so on. So effective, this webinar, but it's optimal. I mean, I would still prefer the physical hearing, and in the context, physical occasion, and in the context of experts, I think, and Gary mentioned something about hot tubbing. I think that's where it's particularly important to get the experts side by side. I think you can do it with technology today, but there's something extra that, putting them side by side when they confront each other on the spot. It's that dynamic sort of quality and the human quality, the things that ego, pride, wondering what my peer thinks of me, side by side, all of that produces a dynamic which is valuable, I think, to the arbitration process. So, so yes, it's effective, but optimal, I wouldn't say so. I think, it always involves some kind of trade-off. It makes sense for you to do it virtually. The pandemic made it perfect sense for you to do it completely virtually. But, what happens if you don't have that? If you have all the resources and everyone is free, would you choose a virtual hearing over a non-virtual? Personally, I wouldn't.
Okay, thank you very much, Rohit and Prakash, for your views. And I think that segues quite nicely to the broader question surrounding virtual hearings. So, the elephant in the room obviously is the COVID-19 pandemic. And, we are unlikely to revert to physical hearings in the same way that they were convened prior to the COVID-19 pandemic. I think it's naive to think that we'll go back exactly as we were prior to this whole pandemic. But at the same time, there are some benefits that must be acknowledged as having, there's some benefits of having a physical hearing, which cannot be currently achieved through virtual hearings. And Prakash alluded to the distinction between whether it's effective and optimal. How will therefore hybrid hearings take place in the future so as to be an effective tool in international arbitration? Given the diverse backgrounds that we have on this panel, I wanted to start with the ladies. So perhaps Gauri and Karen, maybe we could start with you and then work our way towards Prakash and Rohit, because I think it's a fundamental question, and depending on your perception and your background, you may have a very different view from other people.
Shall I start? Certainly, virtual hearings are here to stay. The pandemic is by no means over. But in any event, I mean, we've learned such a lot about virtual hearings in the last 18 months. And there's much to be said for them. I have to say, I really do identify with everything that Prakash was saying just now about experts. And I would say the same about the rest of virtual hearings. The human aspect of a hearing, a real hearing, I don't think you can replicate with virtual hearings, but they have, real advantages, certainly in terms of traveling times, in terms of costs. It's really difficult sometimes to get all the people in the same place at the same time. And there might be logistical reasons, for example, where some of a party, some of their witnesses, or perhaps even their experts can't actually get to the same place at the same time. So there's space within the virtual hearing platform to accommodate all of these difficulties, which you just simply can't accommodate with a physical hearing. And what about hybrid hearings? Well, again, you could perhaps, there are so many possibilities with hybrid hearings. You could perhaps have all the tribunal in one place. I think that helps. Sometimes it helps if all of one party's representatives and experts are in another place, and the other party in yet another place. All of those things are possible, and all of the shades of grey in between are possible. What you have to do, though, of course, is to work out a protocol to ring fence the integrity of the hearing with the witnesses, with the experts. And there are all kinds of protocols now being written. I mean, I was writing one myself last week. So, lots of people are in this space working out ways to do this better. One of the things with virtual hearings we've also seen is a massive increase in the use of technology. Things that I'm familiar with in court in London now become the norm in virtual hearings in arbitration, with electronic communications, with bundles, all of these things which sometimes you would use, you now use routinely. But you have to be careful when you use all these things because there's such a capacity for waste. The other thing I thought with virtual hearings, excuse me, so much more is done electronically. You need to secure the electronic data with these virtual hearings. And I think a lot of the arbitration rules are behind the game when they see what parties are doing. They don't actually make provision for that sort of thing. And that's very important. And I think perhaps that's a rules thing rather than a protocol thing. The other thing with virtual hearings is, of course, the increased capacity to use visual aids, not just PowerPoints, but all sorts of videos and other technical aids. And I know, and perhaps Rohit could talk about this, but a lot of the expert firms now are producing all kinds of different videos and visual aids to assist tribunals. And I think in the virtual hearing space, that is particularly advantageous. It's very nice if you're having a physical hearing as well, but it's particularly useful there. Let me turn over to Gary to give a perspective.
I think Prakash and Karen have explained this very well. I obviously prefer physical hearings, but we all have to adapt to technology. It's my understanding, just a couple of points to add to what Prakash and Karen have already said. One is technology will continue to evolve and technology will continue to change over time. So the 2 points that I would like to make over here is that institutes will have to then offer their own online platform for case management and for virtual hearing platform. And also there will be a transformative use of technology, maybe a greater use of augmented reality arbitrations, as it will allow teams to collaborate better. And lastly, I think I would like to add that arbitrators, lawyers, and clients will drive how technology is used in the dispute space.
Can I just add one thing to what Gary just said there? The only other thing I would add is that with virtual hearings, the thing I find, obviously, I suppose, but the thing I would say is that it takes so much more preparation. You can't wing anything in a virtual hearing. Everybody has to be fully prepared. Thanks.
Yes. That's a great point, Karen. I'm hoping that most people don't think about winging things in physical hearings either, but well taken. Prakash and Rohit, perhaps we could end with you. We've got about 5 odd minutes, so we'll try and wrap up with this question.
Yeah, just very quickly to say, I think I've expressed my view in favor of the physical hearing, and this line of questions, I think it's slightly too pessimistic, I think, about the future of physical hearings. I mean, the starting point, I suppose, is that we already have hybrid hearings very much in play. We had that even before the pandemic. It's it's a frequent thing to have witnesses being beamed through a television screen while we are cross-examining them and so on. I remember quite recently, or before the pandemic, I had an arbitration where even the tribunal was all over the place. One guy was in Germany, the other was in Singapore sitting at home, and the third guy was physically there in front of us. That's a hybrid hearing, and so this is nothing that is unusual for us as our international arbitration practitioners. It's actually par for the course. The issue here is, what these recent developments, has that moved the needle one way or the other? I agree with you, it has, in the sense that it has given us more comfort with virtual hearings and the use of technology. And that would mean that there are more options in place, and I think we would be in a better position to accept the trade-offs that invariably come in when you dispense with a full physical hearing. So now, you'd be far more accustomed to cross-examining people over the screen. Your tribunal need not actually be sitting in front of you, and all of that's there. You now see it in play in a very clear and forceful way. So, and that's probably going to be here to stay, because these trade-offs are very, very important part of the evolution of international arbitration. But at the center of all of this, I think it's still going to be largely anchored by the physical hearing, because there's certain aspects that are actually, that are so valuable that, you would have to specially decide to bargain out of those benefits, which you may do because you want to reduce costs and so on. But, I think when it comes to the major arbitrations where high stakes are involved, I think people will still go back to, the foundational principles of a good hearing. And that means a physical hearing with some adaptations. That's what I think the near future has in store for us.
Yeah, so I think the issue has been quite elaborately discussed and spelled out. Just to add, I'm also, quite in agreement with all the other panelists that hybrid hearings are going to be the future. And with the technology being in place, where you hardly see that any arbitration is getting affected because of technology, people are going to go in for a hybrid model. As Prakash rightly said, the human part of the hearing definitely is missing in the virtual hearing. But at the end of the day, the cost plays a major role. Flying cost and other costs are getting saved. And many a times, what happens is supposedly one or the other witness or expert is not available, or the tribunal is not able to fly down to the place of hearing because of travel restrictions and all. So hybridly it can be handled and it can be done. So I believe hybrid hearing is going to be the future for sure.
Okay, thank you very much. I think we're right at the end of this session. We have about a minute before the next session. Before we get to the next session, I wanted to first thank all the panelists for their views. It's been fascinating just to hear all of your views, particularly given the diverse background that all of you come from. In fact, this question about hybrid hearings, I think I'm not surprised one bit that we do have different views. And it's actually a good thing. I don't think there's going to be one particular mainstream view which has been crystallized yet. I think it's still something which is a work in progress, and evolution will allow us to get the most effective and efficient way to deal with it. There are several different ways we've seen recently of how hybrid hearings take place. So thank you, all of the panelists. Thank you, everyone from the audience, for your questions. Unfortunately, we haven't been able to get to all of the questions due to the paucity of time. But I wanted now to, Tejas, would you want me to hand this to you, or are you, or should we go directly to Shashank for the second session?
Yeah, Ashish, I'll just very quickly come in. Thanks a lot for doing this and doing it on dot. Welcome, Honorable Ms. Justice Pratibha. I'm saying she will be one of our panelists in the next session. The next panel is that we are going to go is on cost, timelines, and conflicts. Is the Amendment Act yielding desired results? And it will be moderated by Shashank Garg. Shashank has recently launched his own law firm. Shashank, over to you.
Thanks, Imran. First correction, it's not a law firm. This is a chamber of practice. Thank you so much. We have, as Imran said, very illustrious panel to take forward the discussions on the topic of cost, timelines, and conflicts. Is the Amendment Act yielding the desired results? We have Honorable Justice Pratibha M. Singh, Judge, Delhi High Court. Thank you so much, ma'am, for sparing time to join us today.
Hi, Shashank. I have a bad cold, so you'll pardon me if I'm not so clear.
No problem, ma'am. Everybody in Delhi is facing something or the other of the related.
Yeah, so I'm sorry about that, but I'll try and be as much as clear as possible.
Sure. We also have Mr. Sanjeev Kapoor, partner Khaitan & Co. and also Vice President of ICC Court. We're also joined by Mr. Amar Gupta, partner JSA. We also have the privilege of having Mr. Tejas Karya, partner Shardul Amachan, the global head of the arbitration practice. Now, just one housekeeping rule, and I'm not sure if that was followed before. If there are any audience questions, I think the Q&A section is active. Feel free to put in your questions depending on the time availability. Some of those questions will be taken up, unless already answered by the panelist in the discussion. Also, when a speaker is speaking, I would request rest of the panelists, if they can, depending on what device they're using, if they can mute themselves, it will just be slightly more clear in terms of audio. Okay, moving on. The first question I have is for Honorable Justice Pratibha Singh. Ma'am, first aspect of these amendments, and when the amendments were being brought, the timelines were a crucial factor that were under consideration in the Law Commission report, also Justice Sri Krishna's report. We have already spent 6-7 years post the 2015 amendment and the first set of timelines that were brought in, which initially were thought to be overzealous and overambitious. But now looking at how the timelines have played in practice, sitting in the High Court, dealing with some of these extension applications and also looking at the timelines of the awards that are being challenged, do you think we have achieved what was desired for by bringing these stringent timelines, or they are being abused and not being followed?
Thank you, Shashank. Look, there are various legislations in India where we have timelines, like the Commercial Courts Act, for example, or the Arbitration Act now that we're discussing here. So whenever there are timelines, even if there is no strict adherence to the same by the courts or by the arbitrators, of course, by arbitrators, they do have a strictness that has to be followed. There is definitely a pressure at the back of one's mind. So it's just human psychology. I do think that in the earlier regime, we have seen arbitrations going on to 10 to 15 years. And at least when I was on this roster, a large number of Section 34s, which I was dealing with in the older kind of regime, they were really delayed beyond reasonable time. And there was therefore, I think, an absolute need to fix timelines. And the 2015 amendment, as obviously all of you know, it was 12 months from entering reference. And that has been slightly modified in the 2019 amendment. Either way, whether it's 12 months from entering reference or from completion of pleadings, I'm sure there are lots of nitty-gritty issues like what would pleadings constitute under section 23(4), whether rejoinder will be included, whether evidence would be included or not. But as it reads, it is only a reply, a main claim and a reply. I do think that keeping the timeline is very important, both for the parties and for the arbitrators, because at the end of the day, arbitration was an alternate dispute mechanism for having quicker adjudication. So not having timelines at all is not a good idea. What it should be, it can be the 2015 amendment, the 2019 amendment, whether it's retrospective or not. There are 3 decisions which have gone back and forth, as you know. And now, as of today, I think the ONGC view prevails from the Delhi High Court of Justice Rao. And I do think that the timelines for various things should be fixed. And my experience in the Commercial Courts Act and the original side rules is that whenever we now do suits on the original side, I realize that because of strict timelines, the situation the situation is improved. Earlier, admission, denial, etc., would take 3 to 5 years. Now, within 6 months from the date of filing of suit, we reach the date of framing of issues. In the same way, I think arbitrators should have a timeline, whether it should be as per the 2015 Act, the 19 Act, what are the intricacies that need to be gone into in that, that's something which we can debate. And whether it should apply to pending arbitrations or not, I would think the spirit of the amendment needs to be looked at, not just the, by the letter kind of thing. And I do realize in arbitration proceedings, there are multiple rounds which keep going one after the other on technical issues rather than on the meat of the matter. So that, according to me, should be avoided. Timelines, to answer your question in one word, yes, timelines should be there. And extension applications, even if they have to be filed, there's no problem. I think, according to me, they just need a one-page order. And wherever the arbitrator is reasonable and the order sheet of the arbitrator is placed before the court, I think these are the 2 things that I would say. First of all, the arbitrator should maintain proper record of proceedings of every hearing. And whenever you seek extensions, that record of proceedings of all dates should be placed before the court. And the court should look at those record of proceedings. If it's reasonable, the extension should be granted. If the court thinks that it's unreasonable on either party or the arbitrator, the court should come down heavily. That's my overall view on this.
Thank you so much, ma'am. That's a lot of positive feedback from the bench on the aspect of timelines. I have a follow-up question for you, Sanjeev, from what Justice Singh said with respect to the extension applications. But before I ask that, your opening comments on the topic.
So thank you, Shashank. So my opening comments would be that effectively, I think, and at a practical level also, we have seen that the introduction of the timelines have really expedited the way the arbitration is actually being conducted in India, and especially so true for ad hoc arbitration. Before the timelines were there, I think there was no kind of a pressure on the arbitrators to finish it in time. We know that in most of the arbitration, at least, there's one party which gains by delay of the arbitration. And there were quite a lot of due process concerns, and people were asked time for extensions, for amendments, for supplemental pleadings, etc. And because of those due process concerns, etc., those would be granted. But now, because the timelines have really come in, I think the process has become very expeditious and very fast. So timelines have really kind of helped at least the ad hoc arbitrations which were happening in India. They are now getting, most of the arbitrations are getting finished within the timelines. There are a few which go in for extension, etc. But those extensions are not of the kind of range and of the stipulated times which we were used to earlier before the amendments came in.
Since you brought this up, I think you must now also answer in your own experience. What is your experience with respect to the extension applications being made? Do you think they are just mechanical, and do you think the tribunals right from the beginning know that the parties with consent would seek an extension? And do you also feel that the courts are being very, very liberal in granting these extensions? And if so, is it really defeating the purpose of bringing in these timelines from your experience?
So the experience, from the experience, I would say that these extensions in many of the cases are desired and required also. We would say that even if you compare a complex arbitration from international standards, how it is getting conducted by any robust arbitral institution also, we will see that these timelines are aggressive timelines. 18 months or 24 months, etc., with consent, etc. These are kind of very, very aggressive kind of timelines, desired but aggressive for a very complex kind of a dispute wherein quite a lot of evidence is to be led. And just to kind of cite an example, many of the construction disputes are actually many arbitrations between themselves. There are so many facets and there are so many unconnected. They are arising out of the same project, but they are kind of mini arbitrations within an arbitration, etc. And I think for those kind of complex arbitrations, etc., you need an ability to extend those timelines. Also, there would be arbitral cases which could be decided within the timelines, but because of genuine and bona fide kind of difficulties which are always there, and which are beyond the control of either the tribunal or the parties, that the timelines can get extended, etc. So in that kind of a scenario, then to be struck with a situation wherein the arbitration process till that particular date kind of gets annulled or a new arbitral tribunal is appointed, etc., I think it's a very good option which is available to the parties to actually go to the court and get those extensions, etc. So as Justice Singh said, there's always a psychological pressure once you put in a timeline. People are wanting to meet those timelines, but for any reason, if you're not able to meet those timelines, the process should be obviously continuing from where it has been left. So from that perspective, I think it's very, very important. Now, the issue would be whether the courts are liberal or whether the parties are abusing this kind of a provision. My experience is no. And obviously, because when you go to a court under 29A, it is not that the courts will grant you for an asking. And it's not that the court has no power except for either extend the timelines or not grant the extension of the timelines, etc. I think the section is quite cleverly worded, and the court is empowered, quite empowered. It can kind of put exemplary cost in case they find the delays for cause of one of the parties. It can actually deduct the fee of the arbitral tribunal also in case they think arbitral tribunal is not conducted in an expeditious manner. It can grant an extension subject to imposition of certain kind of conditions which it thinks fit. And in very rare kind of cases, etc., it even has got the power to replace the arbitral tribunal with a new arbitral tribunal also. So I think these powers which are there in the court and act as a kind of a psychological barrier both on the parties and also on the arbitral tribunal, because nobody wants to end up before a court and then has to justify that the delay is being caused because of the conduct of one of the parties, etc. So I would say that it's a necessary kind of a requirement, and it is a cleverly drafted section, and courts have got the powers to do it. Generally, what is happening is that obviously both the parties are wanting extension. Mostly, in my experience, we have seen is that parties come to a concurrence that, all right, an X amount of a extension might be good enough. Therefore, you file it, and obviously the courts grants it. But whenever the cases get contested, the courts really look at who is the actual cause for this kind of a delay, etc., and has got the powers in case they want to kind of penalize the party which is creating roadblocks in an expeditious disposal of arbitral matter.
Thank you, Sanjeev. In fact, I can completely agree with the view that you have taken, and your experience matches with mine. The reason is, I think the arbitrators are now conscious of the fact that extension application will be heard by the High Court. A High Court will look into the conduct of the parties, and there is an impression that is going out. Earlier, everything was in the closed door. So the fact that something will be brought to the court's notice itself is acting as some type of a safety wall, if I can say. Before moving on with my next question, I just would like to add another housekeeping rule. In case any panelist wants to add something to the question being answered by the co-panelists, can I request you to use the raise hand tab on the app so that I'm aware, and then I can just quickly ask for any interventions that any of you may have. Okay, moving on the next question that I have for Mr. Amar Gupta. Mr. Gupta, in terms of costs, I think the amendments brought in a fresh breath of air for parties who were complaining about exorbitant and arbitrary fees being charged by arbitrators in many matters where there was absolutely no checks and balance. There was no guiding light how to charge the arbitrator's fee. And Schedule 4 was brought in, although it was not made mandatory, and high courts were to formulate rules in accordance with Schedule 4. But we are seeing largely now Section 11 courts are appointing arbitrators with a specific direction in ad hoc arbitrations that Schedule 4 should be followed. But we are also seeing resentment from arbitrators to the fee that is to be charged as per Schedule 4. Is Schedule 4 outdated already in 5 years, 6 years of its existence? Do you think it is adequate in current times, or it requires a fresh look? You're on mute, Mr. Gupta.
That's a bad way to begin. Thank you, Shashank. It's a pleasure to be here on this panel. And good afternoon, ladies and gentlemen. The question on need for Schedule 4 is a complex one. There is a role and place for Schedule 4 in ad hoc arbitration, and as you rightly pointed out, the context in which it was introduced. And it has brought in some kind of discipline. But the Schedule 4 has been losing its sheen slowly because of the decisions that the Supreme Court has given that it is not mandated. The position may change, however, when the 2019 amendments are operationalized, because the language in 2019 amendment does indicate that there is no room for discretion here, and the Schedule 4 will be mandatory. And if it is mandatory, then the need for the amendment, at least, or the revision in the rates becomes much more imminent. Without the revision in the rates, it will be out of pace with the developments elsewhere, and it will not be consistent with the rates, the fee rates for the fee that are prescribed by the institutions. Even at this stage, even currently, there is a great deal of disparity between the rates which are prescribed in the Schedule 4 and the rates which the institutions prescribe. And therefore, there is a immediate need to bring it in tune with, at least at par with the domestic institutions. And whether or not this should be mandatory, that's a separate question. To my mind, in my opinion, for ad hoc arbitrations, there is a need for making it mandatory because of lack of any regulation on fixing of fee. The institutional arbitration should be totally exempt. Even the graded institution under which is envisaged under the 2019 amendment, the amendment provides that the graded institution will take into account the Schedule 4 rates for fixing the fee of the arbitrator. To my mind, that's totally unnecessary. The institutions have robust and wholesome rules regulating the determination of the fee, and that should be left intact and free to operate in the manner that is provided there. But for ad hoc arbitration, there is obviously a need for regulation, and regulation under Schedule 4 is welcome. the need for revision of the rates prescribed in Schedule 4 is of course, is imminent.
Thank you so much, Mr. Gupta. Tejas, I have a follow-up question on what Mr. Gupta said. In your experience, first of all, are arbitrators comfortable with Schedule 4? Are they following it willingly in case there is no direction by a Section 11 court, or especially in cases where there is no need for a Section 11? Parties have nominated their arbitrators and arbitrators jointly have nominated the presiding arbitrator. But in an ad hoc domestic arbitrations, in your experience, are the arbitrators comfortable following Schedule 4 voluntarily at present? That's first. And second is what Mr. Gupta said. There is, of course, a huge disparity between what an institutional arbitration, in fact, if it is an international institution, would provide in terms of fee to an arbitrator in comparison to what Schedule 4 would provide for the same quantum of dispute involved. How do we address that?
Thanks, Shashank, and good afternoon, everyone. To answer your question, Shashank, the cost has always been a paramount consideration for any party who invokes arbitration. And arbitrators' fees, again, is a significant part of the cost of the arbitration, because that is, apart from the institution's fees or the administrative cost or the venue cost, the arbitrator fees is the major part of the entire cost of arbitration. And if you are talking about minimizing or controlling the cost, what is more important is having a clarity at the inception to know what would be the cost of arbitration, because sometimes we have seen parties not invoking arbitration if they know exactly how much it's going to cost, because it cannot be disproportionate to the entire recovery amount in the arbitration or the claim in the arbitration if the cost is going to increase significantly. And there comes the role of arbitrators, especially in ad hoc arbitrations. If I can tell my experience, the arbitrators are not following Schedule 4 in that many cases as they should. The reason being that the fees in Schedule 4 has a cap, and although there are certain explanation in terms of counterclaims and all, but we have seen that the arbitrators are not happy with that, because in ad hoc arbitrations also you have huge claims and complex arbitrations where the rate specified in Schedule 4 may not be justified. The only answer to that is institutional arbitration, because even if we see the explanation to Section 11.4, it excludes the institutional arbitration and international commercial arbitrations. So that is the answer, because in institutional arbitrations, we have a set rules where the parties, by selecting the rules, are also agreeing to the fees of the arbitrators. And that is gives the clarity. In some of the institutions like ICC, SIAC, they have cost calculator on their website. So you put the amount in dispute and you know exactly the cost which would be there in terms of the arbitrator's fees and the administration cost of the institution. And that is where the institutions are carved out from Schedule 4. Even Section 11A, because I was part of the Committee of Law Commission, and that's where we discussed in detail, is that how far Schedule 4 will be successful. And to avoid it being obsolete, we introduced 11A, which gives power to the central government to amend it on a periodic basis, and any notification by the central government would be treated as an amendment to Schedule 4, even although it's an act of parliament. And that is a delegated legislation already envisaged by way of the amendment to Section 11, introduction to 11A. And we have not exercised this of late. It's almost now 6-7 years from the introduction of Schedule 4, and it is high time now that we increase the fees depending on the circumstances of the case. So, of course, international commercial arbitration and institutional arbitrations are not bound by Schedule 4. After 2019 amendment, as Mr. Gupta said, instead of court, now the arbitral institution will decide the fees of the arbitrators. And the best way, in my view, is that rather than following Schedule 4, we should follow the rules of those institutions, because all the institutions, they have their own schedule of fees. and that would be easier for parties to follow rather than having Schedule 4 to be followed. But if not, at least we should consider amending it by central government exercising power under Section 11A.
I think if there are any arbitrators who have joined us today, would be mighty pleased with your view that there is, of course, a need to revise Schedule 4 with immediate effect. Moving on, Sanjeev, I have a question related to the aspect of cost, and this is very topical given the circumstances that we are seeing a lot of discussion about emergency arbitrations in this country. I'm pretty sure everybody who's joined us today would know that emergency arbitration is akin to interim relief at pre-arbitration stage. So if we look at what an emergency arbitration is in an institutional arbitration, an arbitrator is appointed at a very, very short time frame, 48 hours, and has to give an award also in a very, very short time frame, and is paid a fee for conducting those proceedings. Now, when we look at our domestic ad hoc arbitration procedure and we see what the Act provides, there is no such separate fee that is being paid to the arbitrator to hear any Section 17 applications. Now, do you think this disparity should be addressed? Because at times we have seen in complex arbitrations, and as you rightly pointed out, in construction arbitrations, there are so many facets. There's several applications that are filed, and there could be as many as 2-3 on an average Section 17 applications, which would require pleadings and hearings, etc. There is no account for separate fee to be paid to the tribunals for these applications. Do you think there is a mechanism in the Act that needs to be relooked at, or it's all right, we can still carry on with the way it is being carried on?
So, Shashank, the way I see it, there is one fundamental difference between an emergency arbitrator and an application for interim relief, which would be considered in a Section 17. An emergency arbitrator is an arbitrator who is appointed while the arbitral tribunal has not been constituted. So you are wanting constitution of an arbitral tribunal. You have got some kind of an interim relief which is needed emergently, which can't wait till the point of time an arbitral tribunal is not constituted, and therefore you need that interim relief, and you ask for appointment of an emergency arbitrator. Now, the emergency arbitrator who is so appointed is obviously runs into a kind of a mini trial, in the sense that he is appointed very fast. He has to complete the pleadings, and depending upon which institution you are looking at, within 2 weeks to 3 weeks, he has to come out with a kind of an interim award, etc. Once he passes the interim award, then obviously he has no role whatsoever in that particular arbitration. He goes out, the formal arbitral tribunals get constituted. And in fact, the arbitral tribunal which then get constituted, most of the arbitral institutions would have rules which allow that the arbitral tribunal which has been constituted in the normal course, even to vary, amend, rescind, modify the award which has been passed by the emergency arbitral tribunal in case one of the parties applies to it. So you have to compensate a person who obviously is just coming, doing his part of the bit in a very expeditious kind of a manner, because the contours of a case require that kind of an interim order to be passed, and then goes out, and then the normal arbitration comes in. That is a person obviously you need to compensate, and for that obviously there is a fee which is required to be paid as far as the emergency arbitration is concerned. As opposed to that, Section 17 is different. 17 normally would get filed before the person, before the arbitral tribunal, which has been duly constituted and is going to go through the entire gamut of the arbitration up to the final pronouncement of the award. That person is adequately taken care of by whatever schedule has been agreed. If it's an institutional, then institution is paying it. In case it's a ad hoc, then it might be on hourly basis or per sitting basis, etc. Therefore, their cost concerns and how the arbitral tribunal is going to get compensated is forming a part of the larger arbitration process. And one problem which I see with this is that if you start incentivizing the arbitral tribunal for doing a job which it is actually obligated to do, they have to decide an interim application also if it comes in the normal course to them, then we really don't know where it's going to end. Then obviously they might say Section 16 would require a separate kind of a fee structure which is to be paid. An application, let's say, on preliminary jurisdiction might require something else, etc. So I would say that we might not be able to compare an emergency arbitration, which is conducted by a generally a sole arbitrator who comes in for a small time, runs through the process very fast and very extensively, and then goes out, for which he needs to be compensated, versus a regular tribunal, which is getting compensated by whatever the arbitral tribunal structure is, or whatever the fee structure has been agreed by the parties. So I would rather say that in a Section 17, maybe incentivizing a arbitral tribunal for Section 17 is not really required, because the way they are getting compensated for conducting that arbitration is already in place.
Sanjeev, I can assure you that would be an unpopular view amongst arbitrators, but because the general argument is that our lawyers not charging for filing, drafting, and arguing these additional applications, so why should the tribunal not be compensated? But I see the logic, and I also largely agree with you that comparison with emergency arbitrator may not be the most adequate comparison. But I think the disparity really is when there is Schedule 4 and there are no hourly per sitting sort of a fee that is being paid to the arbitral tribunal. But I think moving on, we'll see after Schedule 4, if at all it is revised in the near future, if that takes care of this in any manner. I'll move on to Justice Singh now. Ma'am, any comments on what I had just asked Sanjeev before I ask you a separate question? Do you think the arbitrators should be compensated in addition to the fee that they are entitled to as per Schedule 4 for hearing some of these additional applications? Sometimes they are very, very complex and lengthy applications that are argued before the arbitrator, and it may take 3 to 4 days or even more sometimes just to hear and then do extensive reading.
Okay, again, as you said, that's a sensitive question. But I do believe that once the fee is fixed, for dealing with applications, there ought not to be any additional fee, because then there's no end to it. The whole purpose of having fixation of fee, whether in institutional arbitration or in Schedule 4, is to have a discipline on fee.
Right.
So I think I would agree with Mr. Kapoor. And at the end of the day, I do believe, the fact that most of our arbitrators are either district court judges or judicial officers or high court judges or Supreme Court judges. And according to me, I don't believe that we should start debating this in such a manner so as to make it give an impression that judges are not willing to work without fee. My own impression is that most judges understand their responsibilities, and imagine what we all do when we are in court. I mean, there's no comparison with the amount of work that we do or the remuneration that we get. So it's I don't think judges in general look at fee or arbitration as only a money-making machine. And I think most judges respect the thing that they need to, work in a disciplined environment, and I'm sure they're happy with it. There may be exceptions in your experience, but my own impression is that judges would not be expecting this. Having said that, there's one experience of Section 17 which I've had. Obviously, now that's not possible in the new act, where banks have appointed their own lawyers and ex parte awards have been passed. In one case, I had to kind of intervene in a writ petition because the arbitrator in Chennai, which was an ex parte Section 17 order, directed Delhi police to go to the house of the defendant to recover the money. And it was a shocking case. So I do think, therefore, that clients are also misusing arbitral proceedings by appointing their own, people and getting such kind of orders. So these are different exceptions, but in general, I do believe that applications are part of the process and there can't be a separate fee that can be fixed for that.
Quite well taken, ma'am. Moving on, ma'am, I wanted to ask you, and this is, of course, another sensitive question, but your views, not as a judge, but generally as in your experience, looking at the amendments that have been brought in and the impact of it, especially with respect to the conflict of interest, because Schedule 5 and Schedule 7 was introduced, and then mandatory disclosure format was introduced by Schedule 6. There was, of course, a disclosure requirement even before the amendments came in, but Schedule 6 made it clear how the disclosure should be. And but there's still no consequences of not giving a proper disclosure or giving an incomplete disclosure within the act, other than that, yes, if you get to know of it, you can challenge the arbitrator in 1213, or if it is somebody who's falling in the category of Schedules 7, then possibly move to the court in a 14. But should there not be more statutory consequences for such erring arbitrators if they are giving one incomplete or incorrect disclosures? Both are, of course, very different situations. So an incomplete disclosure would be at a slightly lesser pedestal than an incorrect disclosure where the arbitrator on purpose or knowingly has lied, and then the parties come to know from some sources that no, this is not the correct disclosure. Because otherwise, given the confidentiality of these arbitrations, and even in 34 we rarely use names of the arbitrators, there is nothing that the arbitrator is losing. So he can simply, and when I say of this, I'm also looking at arbitrations which are low scale arbitrations, which are disputes which may not be the disputes Mr. Kapoor, Mr. Gupta, Mr. Karya are handling, but disputes which are 50 lakhs, 1 crore, 2 crores, MSME disputes. And there is a completely different ball game going on when we look at disputes which are within the range of few thousands to a couple of crores. So keeping that in mind, and the arbitrators that get appointed there, should there be more consequences for incorrect and incomplete disclosures?
Again, as I said, these are, very sensitive and ticklish issues. The non-disclosure or the justifiable doubt to impartiality and independence, there are two levels of conflicts which I see. The first level of conflicts are those where somebody says, okay, this person is getting regularly appointed, for example, in an NHAI contract. So he does have some kind of he or she does have some kind of vested interest in ruling in favor of NHAI, so that, or any other institutional organization. That's a different kind of conflict which we deal with. The other kind of conflict of interest is actually the lawyer himself becoming the arbitrator. But this arises not just in arbitrations, but even in court proceedings. Yesterday, for example, I was dealing with a matter in the trial court where the lawyer himself was the power of attorney holder and was the lawyer in the matter. And then there was another case where the forum, for example, in the Provident Fund case, the officer himself was the presenting officer for the department in the same case, and then he became the adjudicating authority. So these issues are to be dealt with on a case-to-case basis. And according to me, it is expected of most arbitrators to disclose their conflicts of interest. And one way in which, there are two ways in which we can solve this issue. I think one way is to make sure that, awards, there is some kind of centralized database of awards. Because I do realize that there is a problem, maybe on NJDG, in one of the cases I've given that suggestion, because there was a challenge in one award, there was an execution. This court didn't know about that, and execution was implemented. So there should be a proper database of arbitral awards, which as of today we don't have. If there is a proper database, one can go and verify, number one. Number two, wherever conflicts of interest issues have arisen and the court has set aside or terminated the mandate of the arbitrator, I do think that the name of the arbitrator should be in the order. So that in future, because we have these legal databases which are easily accessible and, that it's a kind of a peer pressure, societal pressure or ostracism, which you may call, that needs to be there. If it is not there, as you said, sitting in a closed room, just use of the word arbitrator is not enough in my view. If the court feels in a particular case that this was absolutely mala fide, the name of the arbitrator should come in the order. And that's the only way I think we can do it as of today. And if it is institutionalized as we are looking at the amendments of 2019, where there'll be a council, which will be a kind of a high level council, then in those cases, such awards can be sent by the court to the council so that it can be part of their database when they consider that person for appointment again.
I think it's a big takeaway when you said that the name of the arbitrator, at least in a proceeding of termination of its mandate, should be given by
due to conflict of interest, which is mala fide. Yes,
I think that will change a lot, because then with the consequence being there, in the mind of the arbitrator, the conduct of arbitrators would change dramatically, especially in the segment of these smaller disputes. Correct. Where some of these people you may not even know. Some may be a technical person, somebody may be a advocate in some small district where you can't even trace the antecedents of the said gentleman. Correct. So one innovative approach the Delhi High Court is taking these days is that I have seen in Section 11, the courts are not appointing the arbitrator. They're nominating the arbitrator, asking the parties to get the disclosure, and are not disposing till the disclosure is placed before the court. So that itself is making sure that the said arbitrator is aware that the disclosure will be placed before the court, and only after looking at this disclosure, the court is going to confirm such nomination. I think that's a very, very welcome step. I'm not aware if other high courts are following that, but that's bringing in a great amount of accountability.
All this discussion proves one thing, and that is that arbitration by itself may not be a perfect solution. It is arbitration with the court's kind of intervention, or supervision, you may say. That is what, at the end of the day, it is the court with whom the trust and will be built by litigants and arbitrators, or even the lawyers, etc. So I do think that courts play a very, very crucial role in this whole process.
That's right, ma'am. Mr. Gupta, you have an intervention. May I request you to keep it really brief?
Yes, very brief. A very controversial suggestion to address this failure of non-disclosure or insufficient disclosure. It should be possible to treat that as professional misconduct and bring it within the practice rules and penalize it through that process. That process itself is not efficient, but that's one way of dealing with the problem. That's all my comment is.
Yeah, I think that is also a very, very interesting key takeaway. And some of these takeaways, if I think brought to the attention of the Law Commission and the legislature, would be very, very useful. I see Tejas has switched on his video, but before I let Tejas say anything, I would request Mr. Tejas Karya to quickly give his response to the aspect of conflict of interest. Has it been addressed adequately by bringing in Schedule 5 and 7? Very briefly, before I let Mr. Chauhan take over.
Sure, I'll be very brief. In my experience, starting from the discussion with the Law Commission till date, India is the only country which has adopted the soft law of IBA rules of conflict of interest in the legislation by way of Schedule 5 and 7. And this consists of a mix of orange list and red list of IBA rules. In the experience, we have seen that number of arbitrations where same arbitrators were appointed, or the parties, employees were getting appointed have been eradicated. So that is a very positive step. Secondly, the courts have also encouraged the use of Schedule 5 and 7. Disclosure in 6 is mandatory now. So it has helped a lot in streamlining the independence and impartiality obligations of the tribunal, which is a continuous obligation from the start till the passing of the award. So with introduction of 5 and 7, we have seen a complete change in the shift of mindset of the users and the arbitrators in terms of appointment of an arbitrators who are really independent and impartial. The other aspect which I want to also bring for discussion is that it has opened up a pool of arbitration for many other professionals which were otherwise not getting appointed as an arbitrator, because the same set of people were getting appointed again and again by the parties, which has helped to increase the pool of arbitrators. And the institutions have to now play a major role in maintaining the list of arbitrators who are going to get appointed once 2019 amendments are implemented, because instead of courts now under 11, the institutions will be appointing arbitrators. And that would help the arbitrators who are available and expert in that particular field can get appointed, and not by having certain kind of relationship with the parties or their counsels. So that would really help. So I see Schedule 5 and 7 has helped not only to remove the apprehension of bias or lack of independence and impartiality, but also has increased the opportunity for many more people to act as arbitrators and also promote institutional arbitration.
Thank you so much, Tejas. I see there have been a lot of questions in the Q&A and chat window, but I don't think we have the time unless Imran or Tejas says that we can take a couple of them. Otherwise,
yes, in fact, that's what I wanted to chip in with. I think you can take a few questions, 5 minutes, because I think Justice Chandrachud was not able to make it, so he's recorded a speech last night, which is something we'll play. So if you want, please, you could address some questions in the next 5 minutes.
Oh, great. Fine. There are a couple of questions then we would take up from, unfortunately, they are jumbled up between the chat and Q&A window. I think before I take some of these questions, I can simply say, looking at these questions, many of these questions will be answered if you use institutional rules such as of ICC, the issues of conflict, issues of cost certainty, predictability of costs that would be paid to the tribunal, and the institution, and as well as timelines. I think all the three elements that were being addressed through these amendments are being already addressed very successfully by all the eminent institutions worldwide, and ICC is one of the greatest examples of that. One question that I see, somebody has asked that whether anybody from the panelists is aware of a case law wherein a 29A, the court ultimately ended up reducing the fee of the arbitral tribunal while giving extension or while rejecting extension. In my experience, I have not seen that step being taken so far, but if any other co-panelist has seen, can raise their hand. But yes, it's that power is certainly there in the act, and in the suitable situation and circumstances, I'm sure the courts would exercise that power. But what happens in a 29A is that if both parties are consenting for an extension, then there is very limited aspect that is to be looked by the court. If one party is contesting 29A, and that is when the court has to look at the conduct of the arbitrator and also of the erring party. So it really depends on case-to-case basis, but of course, court is empowered. We might not have a ready example for you.
One instance I came across where the arbitrator was appointed by the High Court under 11, District Court, which is a definition of the court under Section 2, refused to entertain 29A, relying on the aspect of that if the appointing authority is the High Court, can the District Court, who has the power to replace the arbitrator, can exercise jurisdiction to extend time. So that issue is slightly tricky. There are conflicting judgments of Delhi High Court and Bombay High Court on that.
Right. I have a question for you, Mr. Gupta. With respect to the proviso of Section 12.5, there are interesting views taken by Madras High Court, Delhi High Court, Bombay High Court on the aspect of whether you can waive Section 12(5) by implication or by implied consent can be, or can there be deemed consent. In your understanding of Section 12(5) and the waiver, do you think if a party has participated in an arbitration and takes up this plea for the first time in a Section 34 of unilateral appointment hit by Schedule 7, would that amount to deemed waiver because they have participated and they waited for the final outcome? Or should the section be read in its literal sense, and unless there is an express agreement in writing, the courts, even in a 34 proceeding, should look at terminating the mandate and setting aside the award?
The waiver of disqualification under Schedule 7 by subsequent to the disputes having arisen, it can only be done by express agreement in writing. And that's the latest position affirmed by Supreme Court. And therefore, any waiver by conduct or by implication or by submission to the jurisdiction or by submission of statement of claim or statement of defense will not be acceptable waiver for the purposes of 12(5). So that's where the statute stands. But is that a good position for the statute to be in? I do not think so, because then without any requirement for the person objecting to the Schedule 7 disqualification to do it promptly and earnestly as at the earliest opportunity, this provision does lend itself to abuse. The objector can wait out the proceeding and depending on the outcome, take up the challenge. So that could be, that's a mischief, or that's the lacuna in the statute that exists. The Section 4 requirement could be extended to 12(5) by prescribing a timeline for raising the objection. There could be a timeline akin to Section 13(2) timeline that the objector must raise the objection within the specified time after having acquired knowledge of the disqualification. So that will bring in the discipline. But I think the requirement that the agreement to waive a disqualification under Schedule 7 must be expressed in writing is wholesome and necessary. So that provision should stay with the rider that the objection must be raised at an earliest opportunity.
Thank you, Mr. Gupta. One final question for Justice Singh before we close this, ma'am. With respect to the amendments that are yet to be notified, Arbitration Council of India has already been enacted but not notified, and the impact of that we'll see in Section 11 also. Do you think once the Section 11 amendments are notified and the Section 11 court has to send all the arbitral appointments to institutions graded by ACI, it would amount to delegation of power, and there would not be any issue to be decided by the High Court then? The entire power is being delegated to the concerned arbitral institutions. Then why there is a requirement of hearing the Section 11 at all? Why should the parties not in the first instance go before these graded institutions? Why do we have these two-tier system as introduced by the amendment, which could lead to further delays in appointment?
I do agree with you. I think it is an experiment which is yet to be implemented, and the effect of that we would not know. But I'm not sure if I have to just predict the consequences of that. The first clear consequence that I see is that the existence of the arbitration agreement and etc., even that is being diluted in the 2019 amendment, isn't it? Number one. Number two, then the court has to just send it to the Arbitration Council of India. And I do see a two-tier process becoming delayed. And thirdly, I have my own apprehension of in eliminating courts and appointment of arbitrators. I, for one, believe that the fact that the power is in the courts keeps the whole process much more fair, transparent, and much more reliable and predictable. Just giving it, again, the entire appointment process to close doors to an institution where certain individuals would be manning those institutions, I'm not very sure about how that's going to work. I'm not saying that it won't work. I just would like to wait and see as to how it is going to span out, because I do believe that institutional arbitration is working elsewhere. I mean, with experiences from ICC, ECAC, etc., we do know that institutions do appoint arbitrators, and there is no problem with that. But the sheer quantum that we are going to look at in India, and how do we create those tiers, and you want to have a central council and then various institutions which are accredited, and then I don't know where the court's role will come in and how it's all going to span out, because our own experience of institutional arbitration through, for example, the DIAC, again, it's not the ideal example, because DIAC is again monitored and supervised by a committee of High Court judges, right? So the private arbitral institutions is another issue. What is the standards that we're going to adopt for having arbitral private institutions, and whether the accreditation process itself will be absolutely fair and good. So they raise, in my own mind, more questions than answers. And I wouldn't want to predict either way, but I'd like to see how this pans out. I'm not very sure at this point.
Thank you very much, ma'am. This brings us to the end of this panel discussion. I think the summary of today's discussion and the takeaway is that we now have very refined questions on the aspects of timelines, costs, and conflicts. 5 years ago, I think we had very broad questions, and with these amendments being brought in and the discussions and the jurisprudence being created through various judgments that have come out of Delhi High Court and other high courts and Supreme Court. Now, the issues are getting more and more refined, and we seem to have answers for many. Suggestions to the legislature and law commissions are going on. The changes that we are seeing in the Arbitration and Conciliation Act are dynamic. So I think we are progressing very rapidly towards making India that hub of international arbitration, and institutions such as ICC are playing a pivotal role in lending that sort of support system. Over to Imran and Tejas. Thank you all the panelists for sparing time and joining us today.
Thanks, Shashank. Tejas, why don't you come in, please?
Thank you so much. Thank you.
Thank you so much. And Justice Pratibha Singh, thank you. We understand that you have a cold and you were able to speak very well and very clearly. So thank you so much for taking the time. I hope you take care and get some rest on the weekend. Thank you, Mr. Gupta. Thank you, Shashank. Thank you, Mr. Karya. Thank you, Mr. Sanjeev Kapoor, for your time. Imran, I think now we had Mr. Justice Chandrachud for his keynote address, but Justice Chandrachud was not able to make it, but he was very kind enough to record an address for us. And that is something that we will play right now. So Imran, if I could just have ICC India put that up, please.
Yes, putting up.
I profusely thank the organizers of this event for letting me present my thoughts through this video recording and for being ever so helpful in the whole process. I must also commend them for bringing experts on arbitration together and organizing this conference, which will facilitate discussions on issues plaguing arbitration in these challenging times. The International Chamber of Commerce has a rich history which travels all the way back to 1919, when it was set up by individuals who sought to introduce common standards to international commerce. In 1923, the ICC International Court of Arbitration was set up to help guide private parties in their arbitral disputes. Since then, there has been no looking back for the institution, which now helps parties across the globe organize arbitrations on a daily basis. Many arbitrations are often on a small scale, with parties, arbitrators, and the cause of action belonging to the same jurisdiction. However, with the growth and complexity of international trade and commerce, arbitration disputes have become equally complex. Arbitral disputes between parties from different jurisdictions are adjudicated by arbitrators from entirely different jurisdictions, governed by the substantive law of a wholly different jurisdiction. Hence, it becomes obvious that parties and arbitrators require a professional third party to step in and help in conducting proceedings smoothly. This is exactly where institutions like the ICC step in. Parties who approach courts are only required to file their petitions and leave the rest to the institution or to the judges. Many presume that courts consist only of judges. However, in believing so, they would be ignoring the role court registries play in resolving procedural issues before the substantive dispute sees the light of the day before the judge. These procedural issues are critical because many substantive disputes cannot be resolved without them and sometimes are entirely dependent on their outcome. Hence, when parties move out of court and into arbitral proceedings, it is unsurprising that procedural issues continue to fester. Institutions like the ICC provide a framework for resolving them conveniently and fairly so that the parties' substantive disputes are not buried in a grave of procedure. Institutionalized procedural rules ensure predictability of outcomes. Not only does this ensure a better experience in arbitral interface, but it retains faith in the fairness of the arbitration process. It allows arbitration to be a process entirely independent of courts, since parties do not have to keep coming back to us for procedural issues which can be resolved by these institutions. Therefore, I cannot understate the role of institutions like the ICC in keeping alive a healthy arbitral framework across state boundaries. From a judicial perspective, it is important that parties have recourse to arbitration as a legitimate option to resolve disputes independent of courts. The Supreme Court and the rest of the Indian judiciary stands in support of the promotion of methods of alternate dispute resolution, with arbitration and mediation being at the forefront. Not only does this allow disputes to be adjudicated by arbitrators who are experts in the areas of dispute, but it also saves judicial time. With the introduction of the Arbitration and Conciliation Act in 1996, and with the passage of amendments, our judiciary must aspire to keep pace with the international arbitration community in order to ensure that the legitimacy of arbitration in India is enforced by its efficiency as a form of dispute resolution. Only recently, the Supreme Court, in its decision in Delhi Metro Airport Express Private Limited versus Delhi Metro Rail Corporation, reiterated the importance of courts showing restraint when examining the validity of arbitral awards and remarked on the disturbing trend of courts to set aside arbitral awards. Similarly, in Jaipur Zilla Dugdh Utpadak Sehkari Sangh Limited versus Ajay Sales and Suppliers, the Supreme Court has dwelt upon the importance of having an independent and impartial arbitrator, thereby holding that the chairman of the applicant company was ineligible to be the arbitrator under Section 12(5), read with the 7th schedule of the Arbitration Act. These judgments underscore the importance of courts acting as an important stakeholder in an effective arbitration ecosystem by ensuring that there is minimal interference with arbitral awards and protecting the independence and impartiality of arbitration proceedings, consistent with the recent amendments to the Arbitration Act. Collectively, these decisions also ensure that the courts are joint partners in making India an arbitration-friendly jurisdiction. India is a growing economy with inflows of investment and our nationals' increasing investment in foreign jurisdictions. With such an increase in international trade and commerce, methods of commercial dispute resolution, such as arbitration, do need to be readily available to Indian parties and their counterparts. The active presence of institutions like the ICC in India ensures that this does happen, since they provide services that match those at the global level. This also obviates the concerns of foreign business entities over pursuing arbitration in India and ensures a more trustworthy dispute resolution mechanism. By its interaction with a variety of parties and practitioners from India, ICC is contributing to the growth of the Indian arbitration community by organizing events like this fourth celebration of Indian Arbitration Day. Events like this allow practitioners to discuss the latest developments in arbitration under the umbrella of the ICC. This is a crucial initiative since each arbitration tribunal is unique and the challenges facing them would often be different as well. Judges speak through their judgments. Arbitrators speak through their awards. But unlike judgments, a substantive foundation of arbitration-based law is yet to gain traction. The credibility of arbitration depends on perceptions of parties and practitioners about the process. The process in India has been criticized to lack professionalism and accountability. Hence, the experience of each of the practitioners starts a conversation. It is through these conversations that we can introspect and let our voices carry beyond our arbitration conference rooms. This can ultimately lead to the adoption of common policies and standards, which institutions like the ICC can then codify within their rules of procedure. A key example of this is the introduction of the 2021 ICC arbitration rules, which include updated provisions for contemporary facilities such as remote hearings. While the ICC could very well have unilaterally made these changes, these new rules were introduced after multiple consultations with stakeholders. The panel discussions in today's events must raise important issues in relation to the implementation of the Amendment Act of 2021 and the importance of all stakeholders in the arbitration ecosystem. The discussion here is a stepping stone through which practitioners can suggest changes to the laws and procedure which govern the arbitration ecosystem. All I would recommend to everyone present here is to bear in mind the spirit of arbitration while coming up with their solutions. This phrase was coined by Mr. Fali Nariman, and it loosely translates into l'esprit de l'arbitrage in French. The meaning of its French translation was explained by the Honorary President of the ICC Court of International Arbitration in the following words. And he said, "The dominant feature of arbitration is mutual understanding, so as to be able to solve the conflict that has occurred. The aim of arbitration is not to draw from the applicable law a decision against the parties involved, but to clarify, together with the parties, what should be done in a given situation to achieve justice with cooperation. This is what I expect from arbitration, whether commercial or diplomatic, national or international. Achieving this process requires all along that all participants are inspired by l'esprit de l'arbitrage." I do hope this is the spirit with which all of you approach your participation in international arbitration. Indeed, it has been long since I was a practicing advocate and participated in arbitration proceedings. And that is true for most other judges. Our understanding of arbitration is based upon the disputes we adjudicate in our courtrooms, which may not provide the best picture. It is also based on coffee lounge anecdotes we hear as judges about arbitrations. Some of the stories about arbitrators may be anecdotal, others may not be quite so. Hence, I am very eager to read about the findings of this event today, since members of the judiciary can also benefit from these discussions. They enrich our understanding of the concerns facing practitioners and in understanding if we can take steps to help alleviate those concerns. Further, they also provide an insight into the priorities of parties when they opt for arbitration, allowing us to learn from them in order to make our courts more attuned for handling complex commercial matters. In the same vein, we do hope that practitioners of arbitration would also find some benefits from our insights as members of the judiciary. As judges, we share concerns over delay and costs in arbitration. In this spirit of exchange, I share my thoughts briefly on the conduct of remote and virtual hearings. The ICC has tried to formalize remote hearings in 2021 in the ICC Arbitration Rules. These discussions have acquired an impetus due to the COVID-19 pandemic. When the pandemic hit us, the arbitration community and institutions like the ICC would have found themselves in a position similar to the judiciary. While the groundwork for potential virtual hearings in Indian courts has been years in making as part of the E-Committee's project, physical hearings have hitherto been the norm. The sudden shift to virtual hearings was not seamless. As chairperson of the E-Committee, I have had to guide the Indian judiciary's shift to remote and virtual hearings. While courts closed their physical spaces upon the arrival of COVID-19 to India, access to justice could not be shuttered. Not just the impact on commercial litigation, but crucially, the violation of fundamental rights and civil liberties occasioned by a denial of access to justice had to be remedied. In framing our response, the first step we took was the choice of a platform for virtual hearings. The ICC would have had to make this choice from among available options. By now, all practitioners at this event would have attended virtual hearings using many such platforms. They have their pros and cons. We belong to a profession which is taught to question. Hence, the choice for us was not an easy one. The choice for the judiciary was not only dictated by our or the party's convenience, but ease of access across the country. Once a platform was selected, it was about adapting our procedures for physical hearings into those for virtual hearings. While this may sound simple, it is no easy task because the process of business process re-engineering must ensure that substantive rights are not compromised. After this was done, the biggest issue was obviously making the members of the judiciary, the registry, the staff of the Supreme Court, and even the members of the Bar Association comfortable with using virtual platforms. This was one of the toughest challenges we faced and continue to face. Since the status quo bias in favor of physical hearings is particularly strong, everyone is bound to be averse to making the shift to the virtual world. On a personal note, even I remember the difficulty I encountered when having to read a 1,000-page on edited without secretary decision working in any level of principle. Virtual hearings offer a similar level of convenience since from the safety of their homes or offices without having physical to court. Particularly important, which is located in Delhi, but it is country. It would be my understanding that this is also for beginning since they are more likely parties and arbitrators from not only different places and jurisdictions as well. After all, just as the Supreme Court should be easily accessible to individuals from across India, international arbitrations can remain truly international, able to attend such proceedings without having to be tied down to geographical locations. International arbitration must become truly global in substance as well as in form. However, before I end my address today, I must offer a note of caution that should accompany the shift to virtual hearings. While the shift to virtual hearings showed us the potential for a more efficient method of dispute resolution in the courts, it also exposed glaring issues of access. Not only did these issues arise in the context of individuals who were unable to participate in the hearings due to a lack of access to facilities and issues of digital literacy, they also arose in the context of individuals with disabilities. In response, the E-Committee ensured that it was the duty of all high courts and district courts to provide facilities and training to every advocate who wished to participate in the virtual proceedings. Similarly, we ensured that all websites, documents, and necessary infrastructure are modified in a way that it became accessible to individuals with disabilities. Change does not happen in a day, and the challenge continues. This is my note of caution because the arbitration community will face similar issues while conducting remote hearings, and it is important to address them upfront to make the space more inclusive for everyone. It is on this note that I would like to end my address. We live in times of challenge, but humankind has rested on its optimism of fashioning a better future. So it holds for our profession. The discussions must lead to positive change in the framework of arbitration proceedings. While making those changes, our solutions must be inclusive to ensure that convenience does not trump access. Thank you very much, and all the best for an amazing event.
Thank you very much, and apologies for the bit of a glitch that we had there. We will surely be uploading this on ICC YouTube channel and also sending the link in our thank you note. Now, for the vote of thanks, I may please request Mr. Kunal Vajani. Kunal is a member from India of the ICC Court, and he is also head of chambers, Blackrock Chambers. Kunal, the floor is yours. Thank you.
Thank you, Imran. Good afternoon, all of you. And I think, as usual, I am always within the lunch and all of you. So I once again apologize for the same. I think this afternoon, I must compliment ICC India for organizing this great event where we've had focused, intellectually stimulating discussions. Beginning with the special address by the Vice President of the Court, Mr. V.K. Raja, who laid down a roadmap for a cost-effective, impartial, and a time-efficient arbitral ecosystem in India. The next panel, steered by Ashish Chuk, wherein the most important aspects of large commercial disputes, which is the role of the experts, was deliberated, discussed, and fought upon. Experts today play a pivotal role in the commercial bandwidth and the fiscal decision of how an arbitral tribunal would award damages as well as compute the costs which are involved in the claims being made by the parties. An expert's role becomes an aid to the arbitral tribunal, which may not be equipped with that kind of technical advantage or knowledge to adjudicate the disputes effectively. The next session, steered by my dear friend Shashank, and the august presence of Justice Pratibha Singh, not only discussed the various aspects which have arisen from the latest amendment, but also the previous amendment which was incorporated under our arbitral laws. The importance of impartiality of arbitrators, the importance of the misconduct as outlined by my friend Mr. Gupta, are live issues which are being adjudicated, deliberated, and debated upon by the courts in India. One of the questions which my dear friend Shashank addressed to Mr. Gupta also arises to be a latest issue of which I have personally been a party. The waivers, the tacit waivers, the implicit waivers, or the deemed waivers is a question that is being asked and mirrored with what is called as the spirit of arbitration. The ecosystem could not have been developed to be a dangerous one, where the impartiality has been overlooked or could be overlooked with the zeal of upholding an award for the sake of the spirit of arbitration. Followed by this panel, we had the virtual speech by Dr. Justice Chandrachud, who outlined the importance of arbitral institutions and institutional arbitration, one of which I advocate myself personally as being a first-hand stakeholder involved in institutional arbitrations. The importance that an institutional arbitrations can aid with the assistance of an active court is incomparable to an ad hoc arbitration. With this entire deliberation that we've had since this morning on a Saturday is going to lay a fantastic roadmap for the 5th ICC India Arbitration Day, which I will beseech my dear friends Imran and Tejas to try and organize it physically and at the earliest. We all need to get back to see each other, to greet each other physically. I once again thank all the moderators, all the panelists, all the special speakers, the president of the ICC court, who was kind enough to also forward her virtual address, my friends Imran and Tejas for putting together this wonderful event, Mr. Sudhir Lamba, who has assisted Mr. Imran in putting together this entire conference for the day, the sponsors who have aided and assisted ICC India to ensure this event becomes successful. I must also compliment Imran and Tejas. I, since morning, was concentrating also on one small number going up and down of the participants. And let me tell you, this conference, as I saw just not the numbers, going up to 150 almost, but had the august presence of Reverend Fali Nariman and certain barristers like David Bramord from the United Kingdom. I think, although as outlined by Dr. Justice Chandrachud, a virtual world has a different benefit that we could have the august presence of participants of great stature, but I think we must get back to the physical world as soon as we can. Thank you very much to everyone for putting together this great afternoon and reconnecting with ICC once again. Thank you.
Thank you.
Thank you, Kunal. Just one edit, if I may. It's usually you standing between the audience and the bar, because this is something that is followed by cocktails, not lunch. So hopefully next year we'll have the ICC India Arbitration Day in person, where we'll also have the cocktails. Thank you so much to everyone for taking out the time. It was a pleasure having all of you, and we hope to see you again next year. Thank you.